Good morning, ladies and gentlemen, members here, those online. Thank you for joining into this today's discussion on this 2025 annual tax symposium. Before we start, we're going to dive into a discussion on alternative dispute resolutions, tax appeals tribunal application, and tax appeals. And the distinguished panel before us is going to help us dissect some of the issues that have been disturbing tax litigators, taxpayers, and tax professionals. But before we start delving into that panel and I introduce my panel, I'd like to invite the treasurer of Uganda Law Society, Mr. Arthur Isiko, to officially open the tax symposium and give their opening remarks. Mr. Isiko, over to you, sir. We can hear you, sir. Arthur, we can hear you. Thank you very much, Mr. Isiko Arthur, for those opening remarks. Without taking words from your mouth, I would like to invite Mr. Kule Roland to open the discussion with a word of prayer. I think we should stand so that we say a prayer, then.
Heavenly Father, we thank you for this moment. We entrust this symposium and the entire discussion into your able hands. Protect us and give us good health and guide all that we are going to discuss today through Jesus Christ who prayed. Amen.
Amen. Thank you, Mr. Kule. After the opening remarks of the Uganda Law Society and such a powerful prayer from Mr. Kule, I think we're ready to start the discussions for today. Today, we start off with a very interesting discussion. I've kept on saying that I'm not worthy to be on the table of this panel, but here I am. Miracles do happen. On the panel is Mr. Cephas Birungi. He's a senior partner and a very seasoned tax practitioner. He needs no mention. He's a partner at Birungi, Barata and Associates, and he has been practicing in the tax sphere for over 20 years. Mr. Birungi brings a wealth of experience, and we believe that we're going to benefit from his many years that he has served in this particular sphere. When they usually say that when you want to know the road, ask those who are coming back. Mr. Birungi has walked the road, and I'm sure he's going to give us a very good discussion today. Mr. Birungi, you're welcome. We also have...
Thank you again. Good morning, everyone.
Good morning. We also have Ms. Crystal Kabajwara. She's the chairperson of Tax Appeals Tribunal. She has also worked with PwC in Uganda. Many of us have interacted with her at the Tax Appeals Tribunal, and you know when you're in her court, it's no nonsense. She's very strict. So as I keep saying, I'm not worthy to be seated on this table. Ms. Kabajura, you're welcome.
Thank you, Ian, and good morning, colleagues in the profession. I'm happy to be here.
And last but not least, we have Ms. Catherine Donovan Chokunda. She's a commissioner, legal and border affairs at the Uganda Revenue Authority. This is an important person to know because when things get legal, she's the one who has a final say. Ms. Catherine, you're very welcome to this panel.
Thank you, Ian. It's lovely to be here, and we look forward to the engagement.
Thank you. I know all of you are willing to, more than ready to ask questions, but I have the microphone today. So I'll ask the question on your behalf, and then if there are any other things that you need to be discussed, we can throw them in the comment section. And those who are present here will have an opportunity maybe to ask one or two questions. But allow me to start off with Ms. Catherine Chokunda. And we're discussing ADR, tax appeals, and tax appeals tribunal specifically. Ms. Chokunda, we have had the ADR team, or ADR has been established in the URA for about 2 years now. And I know it's fundamental in resolving tax disputes after objections, but we'd like to evaluate the performance of ADR so far. How has it performed, and what would be areas that you think would be recommended for reform?
Thank you, Ian. That's a very useful question indeed. The alternative dispute resolution was formally embedded in Uganda's tax laws in 2021 with the Tax Procedure Code Act under Section 26, subsection 11. It was effective 1st July 2021, but the regulations only came into force on the 6th of March 2023, and that's where the ADR began from. In terms of the practice, ADR had challenges in terms of the set-off, I think really in terms of the framework. I would say the most effective start of time was in the year 2022-2023, where we had a number of cases that actually indicated the relevance of this particular mechanism for settling disputes. The alternative dispute resolution mechanism started with about 1,303 cases in the year 2020-2023. And that in itself indicates the relevance and the need. Since then, the cases for 2023-2024 were about 2,370. 2024-2025, the cases are on the rise with about 2,537. But I think more importantly is the cases received against the cases that have been completed. The stats reflect that in 2022-2023, we had 1,168 cases that were completed. And due to the capacity building, in the year 2023-2024, we had more cases concluded to the tune of 2,489. In the last financial year, the figures went up to 2,547. And the trend has been that we've had less cases carried forward. That really indicates that this is a very critical section within the URA mechanism for settling disputes. And that progression in terms of the numbers shows that a lot of people are actually tending towards the alternative dispute resolution mechanism for settling disputes. I would say there's still room for progression. We are working on a number of things to make it more effective. Ideally, it shouldn't be a place where we have cases carried forward. So that is really what we're working towards, to get more effective, to ensure that actually it's not just the volume of cases coming in, but we have the capacity to handle all cases efficiently and effectively. Thank you.
Thank you very much, Ms. Chokunda. I'll come back to that. I've put a pen on the completed cases, 2,547. We need to know if they've been completed, dismissed or resolved, but that's a different story, but we'll come back to that. I'd like to move on to Ms. Kabajwara on the Tax Appeals Tribunal. Again, Ms. Kabajwara is fresh on the chairmanship of the Tax Appeals Tribunal, about 1.5 years, and she has been at the helm, but we've seen various developments since she has taken the reins. I'd like her to talk about the developments of the Tax Appeals Tribunal and what would be the successes that you've registered in this 1.5 years.
All right, thank you, Ian. Before I comment on our successes and developments, I would like to take this opportunity to thank the ULS for having organized this symposium, as well as the Uganda Revenue Authority for having graciously hosted us. And for the benefit of our listeners online and those who may not have interacted with the Tax Appeals Tribunal, our mandate is to resolve disputes between URA and taxpayers. And our mission is to provide the public with a clear, uniform, rapid, and just system of resolving tax disputes. So in view of that, I'm happy to report that last year was quite impressive. And in the 27-year history of the Tax Appeals Tribunal, we were able to resolve disputes worth over 500 billion shillings. So we crossed the 500 billion mark. And I'd like to thank specifically, this is down to the efforts of our team at the tribunal, but also our users, the taxpayers and the URA, who have really cooperated with a number of changes that we have introduced in the year to ensure that we are resolving disputes rapidly. So that represents a significant growth in the number of in the value of disputes that we resolved, looking at about 100%, 131% growth. The number of disputes has also increased that are filed with us. which well is both a good and bad thing, because you'd want to have as few disputes as possible, but the reality is that we'll always have tax disputes. So if you look at the 5-year trend, we've seen a growth in disputes by almost 150% from 2020 to the current time, where we have about 400 new applications filed annually. Right now, our caseload is close to 500 disputes with a value of about 1.2, 1.3 trillion shillings. So we still have a lot of work ahead of us to do. How have we been able to deliver on this front? One, we've tried to increase our capacity to handle multiple disputes at the same time. And we've done that by operationalizing a second courtroom. So for those who have been to a tribunal, maybe who are there 3 years ago and today, you'll find that you have 2 courts running concurrently. And that is to ensure that we are disposing of as many matters as possible. We've also tried to simplify our procedures and as much as possible reduce and eliminate technicalities and formalities, because as you appreciate, a tribunal is primarily administrative. Our role is to review the decision of the commissioner. But over the years, I think because it's dominated by lawyers like yourselves, we've tended to take it back to conventional court system, but we're trying to take it back to what it's meant to be so that we are using it to resolve disputes the way they should be done. We've also been able to democratize access to information. So I'm sure many of you are able to receive our cause list on your phones, on X, on LinkedIn. We have a WhatsApp channel, which you can follow for updates. We set up a website. So a lot of our information is out there, which is really contributing to taxpayer education and sensitization in a way. And speaking of, I think, development, we continue to ensure that we are reducing technicalities, but also going forward, we want to focus more on taxpayer sensitization and education and more awareness about the tribunal. But also from a court user perspective, we have noticed over the last 3 or 4 months an increasing rate of adjournments in the tribunal. I don't know what's happening to our users on both sides, so we'll be reaching out to you to ensure that we're bringing you back in line by ensuring that you're respecting timelines, you're respecting your appearances, and that adjournments are minimized because we have such a huge caseload to deal with. So my ask is that as we enforce these rules and tighten the loopholes and the gaps, please try your best to comply. Thank you.
Thank you, Madam Chair. I can attest that there's been great stride in resolving matters at Tax Appeals Tribunal. But then that brings us to a more interesting discussion where I want to move to Mr. Birungi, who is online. Tax appeals, and these are appeals from the Tax Appeals Tribunal to the higher courts, the High Court and other courts, appellate courts. We've had decisions coming in recently where there's been challenges in these appeals. Mr. Birungi, in your experience, how different are tax appeals from the ordinary appeals that we know? How different are they? Mr. Birungi, over to you.
Thank you, Ian. Tax appeals are fairly different from the rest of appeals because they are within a specific jurisdiction to start with, the Tax Appeals Tribunal. Most other appeals emanate from either the High Court or the Magistrates' Court, and they have got specific legislation about how the appeals should be conducted. The way appeals are done in the Tax Appeals Tribunal is that it is regulated by the Tax Appeals Tribunal Act, which provides how they move right from the Taxing Act. It is very important for you to understand that an appeal is technically starting from the objection stage. And that is where the law is very clear that there should be an objection decision or a tax decision. A number of failures happen at this stage where either the timeline for an objection decision are not followed or the timeline for a taxation decision are not followed. There is a lot of dispute as to what is the objection decision and what is the taxation decision. And that leads from appealing within the URA to the Tax Appeals Tribunal. As you may be aware, it took some time for it to be settled that one should start in the Tax Appeals Tribunal rather than in the High Court or in the Magistrates Court. When that was settled by the Rabo decision, then it became a one-way street through the Tax Appeals Tribunal. And after that, as you may recall, it was not clear whether there was an automatic appeal to the High Court or not. The different taxing statutes provided differently, but that was later harmonized to make it straightforward an appeal to the High Court. And then later on, to an automatic appeal to the Court of Appeal. When you look at the provisions now, they say that for you to appeal to the Supreme Court, you need leave of the Supreme Court. Whereas previously, you needed leave of the Court of Appeal. So for one to understand the appeal process in taxation, one also needs to look a bit at the history. But know that therefore, you need to follow the Tax Appeals Tribunal rather than the Civil Procedure Act, which may guide you how to appeal, or the Court of Appeal rules or Supreme Court rules, which are authorized appeal. So in a way, they are different. So that is important. Over to you, Ian.
Thank you, Mr. Birungi. As I was still on that, after giving us a difference between the appeals, tax appeals, and ordinary appeals, how then should a lawyer prepare when they are handling appeals, especially to the High Court and the Court of Appeal, in your experience? Still with you, Mr. Birungi.
So the main thing is that appeals from the Tax Appeals Tribunal to the High Court should be on points of law. So for you to prepare properly, it's important that you should have done a good background in the Tax Appeals Tribunal. If in the Tax Appeals Tribunal you didn't emphasize the points of law which are likely to come up on appeal, because if you are litigating, it's important for you to know that you might fail at that stage of appeal. So you also have to have your eye in the rear view mirror or in the front mirror, knowing that if I fail at the Tax Appeals Tribunal and I'm going to the High Court, what am I taking there? You must know that you are taking there points of law purely. So if you merely urge points of fact and your emphasis in the tribunal is on matters of fact, you need to know that when you fail at that stage, you may have no recourse in the High Court. So after that, going to the High Court, it is important for you to take into account the fact, the timelines are a big factor in most of these dispute resolutions, and I believe the chairperson will bear with me that timelines take about 30% of the issues on appeal. Many people fail on the timelines. So you must be in time to appeal. And when appealing from the Tax Appeals Tribunal to the High Court, you appeal by notice of appeal, which is different from other cases where you have to have a memorandum of appeal, which is more detailed. But your notice of appeal should point out the points of law which are in dispute. So you must to show the areas of appeal and emphasize that, point out that the areas of appeal are points of law, so that you do not have your appeal thrown out at the High Court. And of course, like the rest of the appeals, you must have your record in place, because you will be appealing on what was decided at the High Court, and the record should be very clear. The appeals in respect of the Court of Appeal and Supreme Court, I think, follow the same rules. You are merely at the Court of Appeal or Supreme Court, you are emphasizing that the High Court decision was made against the law. The judge in the High Court didn't conceive the law the way you conceive it, so you hope that the Court of Appeal panel will understand the law the way it should be, which is the same point you would want in the Supreme Court. But as I said earlier, in the Supreme Court, you need leave. When you look at the laws in place about these appeals, they have some provisions which are fairly impractical. They say that the Court of Appeal should dispose of an appeal within a specific time, a very short time, which you are not in charge of anyway. So is the Supreme Court. I wonder how one can enforce that the Court of Appeal disposes of a matter within 6 months. We have, I believe, just itself could take you another 6 months. If these matters were taken the way constitutional matters are and given a fast track, possibly this could happen, but in practice, I'm not seeing this happening. Over to you, Ian.
Thank you, Mr. Birungi, for breaking down appeals and what you should be prepared for. I'd like now to jump back to the ADR process to Ms. Chokunda. Yes, Mr. Birungi, can you hear us?
Yeah, you can hear me?
Yes, we can hear you. Sorry, we're muted. Thank you very much for enunciating the things that are required to prepare for an appeal. I'd like now to jump back to the ADR discussion. Ms. Chokunda said that they had completed 2,547 cases through the ADR, but there's still an outcry from the taxpayers. One, there's a perception of lack of independence of the ADR team, but also the delays. You have to go to reviews, oversight committees, and delays and things like that. So they still mention some challenges in the ADR process that needs to be reformed. How is the URA trying to handle these perceptions of perceived biases or lack of independence and then the delays? Ms. Chokunda.
Thank you for that question. It is indeed important to recognize what is indeed the perceived delays and whether we are addressing them or whether they are actual delays in reality. Numbers speak volumes. Between the period 1st July 2022 to the 30th of June 2025, URA received 6,823 ADR appeals. And from that volume, 6,204 ADR decisions were made during the same period. So in terms of the delays, I think one of the key issues is our ADR system under the regulations, we don't have a timeline. There's no statutory deadline. And I suppose in a sense, the fact that taxpayers are aware of a timeline to go to TAT creates an indirect timeline for our ADR. So from an institutional level, we have got standard operating procedures. And for this current year, we are implementing 28 days for the ADR team to have handled and completed the matter. But that's the full cycle. In order to deliver on this, we've increased the number of staff handling ADR matters. We've looked at the competency gaps and increased and enhanced that, because bear in mind, for instance, if a matter is coming from audit and it goes through a whole system, some of the matters are complex in nature and they require a lot of detail and review. So we are working on the capacity building of the people in the ADR space to ensure that they have a quick resolution of matters which are pending. The issue of lack of independence is dealt with because under the setup, ADR, before I joined last year in 2024, ADR happened to have been under domestic taxes as a department. And we deliberately moved it to the legal department to create that level of independence. The matters arise from the Domestic Taxes Department, from Customs, and from Tax Investigations Department. So the segregation of departments is a real attempt at creating independence, because the matter is being reviewed by a person who has not dealt with it previously. It's not the assessor, it's not the person who dealt with the objection decision. It's a different department. And essentially, it's a different group of people who are reviewing the information, the facts, looking at the law and making a decision. So I would encourage that indeed, if you perceived any absence of independence, at least given the segregation of the departments, that should not exist, but we're open to feedback. In terms of delays because of the oversight committee, I suppose from an external perspective, one would think that that's now another hurdle and therefore it's delaying the process. From an institutional perspective, the ADR Oversight Committee is really for purposes of looking at quality assurance. And the reason for that is when you look at the case that arrives at the ADR team, that matter has gone through an assessor who raised the tax. And that assessment stands. And the objections team has gone through that, reviewed that matter, and upheld a certain tax amount. So for that amount then to go to the AGR team and, for instance, come to a resolution that actually the entire tax should be vacated is a matter that, as a public institution accountable, we have to ensure we quality assure what we have done. We have made the ADR oversight team purely handle these matters. So they do not do any other assignments other than dealing with matters that come to the oversight committee for review. The members are full-time, and that's all they're doing so that we can ensure efficiency and effectiveness. Perhaps another thing to note is the composition of this ADR oversight committee. It consists of experts from different departments, including the legal department, customs, tax investigations, and domestic department. And they bring their expertise and look at this matter, bearing in mind they're looking at it with fresh eyes and haven't looked at it. And the key things for them to validate are the findings of the ADR team and the adherence to the standard operating procedures, timelines, and whether it's within the law. And that's all very important for quality assurance of these adjustments and decisions from the ADR team. Part of the reason why is if you look at the statistics, the ADR portfolio analysis, when you look at the objection decision compared to the amounts after ADR, there are some adjustments made. For instance, in the financial year 2022-2023, the tax at objection was 290.8 billion. And the tax after ADR was 192.2 billion, a percentage reduction of about 0.34. Now, in the year 2023-2024, the amount was 714.1 billion at objection. And that amount was dropped to 599.2 after ADR, a percentage drop of 0.16, which means, in a sense, we are giving feedback to objections, we are correcting things, and there's an assurance in that. Whereas if we are not quality assuring these matters and these decisions, one would ask, how did it drop? Is it correct? Is there something wrong? So it's really for quality assurance, and there's a lot of comfort in the fact that in the year 2024-2025, tax at objection was 1.1 trillion, and after AGR it was about 929 billion. So the percentage reduction was 0.12%. So that's progress and that's improvement. And we need to be able to see those statistics. And that is why you have an objections at NADR Oversight Committee to ensure the quality and standard of what we're producing. The delays are covered by the fact that this is their full-time job. They are required to have a turnaround time. So within the week, when they receive these matters, they have to be out. And the decision will then be made and the settlement agreement reached to ensure there are no delays. And I believe that, in a sense, that also gives comfort to the taxpayer and everybody else out there that we are accounting for the tax and doing the correct things as an institution. Thank you.
Thank you, Ms. Chokunda. I want to stay with you on that point. You have enunciated very well that it's a perception issue, and you have actually managed to reduce some of the taxes that have been approved at the objections decision. But then, how can the tax practitioners assist ADR or embrace ADR's legal framework so that they can assist their clients we go through these issues?
I think that's a very valid question. One of the biggest hurdles we have is taxpayers' sensitivity and understanding that even ADR exists. Because in the current, one of the things that the practitioners would really help taxpayers to understand or appreciate is the timelines. One of the requirements is that you should make your ADR application within 7 days of the objection decision. Given the context of we are a developing country, hoping to be developed, but our taxpayers are people who may not be aware or conversant with these provisions at all. So it's our duty, our job, to really sensitize on those critical timelines and also to show the benefit. Because whilst a lot of people may be aware and alive to objections team and what they do, that, you've got a tax decision, you can object and they'll review it. Not everyone is aware of the ADR. And a typical example is yesterday we dealt with a taxpayer who was really aggrieved and had not been aware that ADR existed. But clearly their situation could have been very well resolved under ADR. And a large part of that is because of the benefits that ADR offers. Taxpayers and tax practitioners will agree that taking matters to the court system, whether it's through TAT and going on to the High Court and other higher courts, is really an expensive it's an expense. It's an expenditure on the taxpayer who has already felt aggrieved by the fact that they have this assessment. There is also an impact on interest. So it's accumulating, the value is accumulating, interest is accumulating. And at the end of the day, really, both the taxpayer and the public and URA are not the greatest beneficiaries if the matter is not resolved quickly. So the ADR approach really should be something that we all advance because it helps us to resolve particularly factual matters. The courts are there and they would really help us where there's a difference in interpretation or it's a legal interpretation where we may just fail to agree, or a new area, it's an emerging issue which needs a lot of analysis and technical know-how and both sides disagree. So there will always be relevance for us to go to court in certain instances. But the majority of disputes happen to be factual. And where a person, for instance, has received an objection decision, but they insist that actually not all their documents were looked at, or they delayed to find the documents. There was a delay somewhere. Sometimes we have instances where people say, I was actually in hospital, or the person who was the accountant was not around at the time, but the email in the system goes to this person. So there are so many reasons where you may find people are struggling. So the sensitization for people to know that, okay, this matter is at objection. I'm expecting an objection decision. I have to be ready to go to ADR and to know that there is an alternative way to resolve the matter. And Another thing would be for taxpayers and tax practitioners to be more sensitized on the relevance of bringing documents, because a lot of the matters that are being dealt with at ADR is factual issues. It's where documents were not provided in time. Maybe the person needed to go and get bank statements, but it took so long. So time ran out because the other areas have statutory timelines. And by the time they come to ADR, they've got all the documents. We still have to authenticate that they are correct and true documents. But ultimately, you find the documents clearly indicate the tax should not arise in those instances, and nobody should be paying a tax that is not due. So I suppose really our plea would be for tax practitioners to embrace the ADR as a way of resolving disputes. And where things fail, we can always go to TAT, we can always go to the higher courts for legal interpretation. And ultimately, it's a much more effective way for reviewing the documents, especially since even when they go to TAT, you now have TAT-guided mediation, which in a sense, again, is another review session. So it's a very effective way to deal with matters, and would encourage all of us to really sensitize the public on these avenues of resolving disputes. Thank you.
Thank you, Ms. Chokunda. I think you've campaigned for this ADR very well, and people have understood what they need to do and how to support. I'll jump over to Chairperson of Tax Appeals. When you look at us, when you've come to your court as practitioners, sometimes we make errors, and you hope we didn't make such errors so that your work is much easier. What are some of the common mistakes you see practitioners make on the other side of the bench?
I'd like to widen practitioners to include the taxpayers.
That's all right.
As well as the URA.
That's okay.
Yes, okay. I think at the risk of sounding like a broken record keeping is always a challenge, especially in the SME space. For taxpayers who are operating in the SME space, our statistics show that they have a higher propensity of losing their cases because of poor record keeping. And just like Ms. Donovan said earlier, that tax is fact intensive, and you need documentation to support your position. So when you don't have your documents in order, you don't have your records in order, you begin from the back foot. So it's always important that we are sensitizing taxpayers to adopt a culture of good record keeping. And related to that is the failure by taxpayers to provide information on time. They have the records, but then you wait, you don't provide it at audit, you don't provide it at objections, then you wait for mediation, when finally the matter is before TAT, to provide information that you should have provided at objections. And I think the law is clear. We've been lenient, but given the workload that we have right now, we're going to begin getting strict with taxpayers who provide their documentation late. But in the same vein, on the URA side, we've had complaints where documentation is provided especially at objections, and it's not reviewed, it's not looked at. And had you looked at that information, you would have arrived at a different decision. So we're ending up with so many cases that shouldn't be with us just because somebody at objections didn't do their work. And I think the other common mistake, especially for the tax practitioners like the lawyers, is leaving your clients behind. I don't think your client's attendance in any way diminishes your role. But remember that this dispute began at audit. You are not part of the audit. It then went to objections. Most likely you are not part of the objections team. You've come in at the tail end of the dispute, which is fact intensive. And when you come to the tribunal and you're asking you the difficult questions, and you say, oh, I now need to bring my client. But where did you leave your client behind? Especially at conferencing. And for those who have participated in conferencing, I hope you can see that it really helps unlock the dispute faster. So I would like to encourage all of you to ensure that, please, when you're coming to the tribunal, do not leave the taxpayer behind, do not leave the assessing officer behind or the objections officer behind. It simplifies your work as well. Submissions. I think it's safe to say that your case, at the end of the day, the ruling or the decision will be as good as your submissions. I always joke with my colleagues from the URA that don't give me 5 pages on burden of proof and only 2 pages on the analysis. Yes? We need better analysis because you're going to need that, especially on questions of law, when you're going to appeal. So if your submissions are not well drafted, the arguments are all over the place, they are not chronologically flowing, then you're going to have a challenge further down the line. We're going to take a longer time writing your decision, writing the ruling, because the submissions are not properly presented. And then also, I think on the side of, on the URA perhaps, is sometimes you can see submissions that have been prepared and you can tell that the user department was not consulted in the drafting of those submissions, especially for technical and complex matters like international tax, transfer pricing. It's important that you break out of the silos and you work together so that you're getting the best, the practice, the best practice and developments, and you're incorporating all that into your submissions. Because as a legal practitioner, you're probably in the legal department, you're probably handling 1 international tax case a year, but the guys in the ITX division or in CDT, in domestic taxes, are dealing with those cases on a daily. So it's always important that, especially at a submission stage, it is consultative. Then also, I think on both sides, there is generally a lack of understanding of the taxpayer's business, the economic environment in which they are operating, government policy. Tax does not operate in a vacuum. And for you to be a good tax practitioner, it's important that you're switched on what's happening around you, what's happening. If you have no business representing a taxpayer in the banking sector, if you have not taken time to understand the banking industry, you have no business. If you have not taken time, if you're from the URA, and even taxpayers, from the as a lawyer, when you don't know what was in last year's budget, you haven't read the NDP3, you haven't read even NDP1, you don't know how it has, you don't know what's in Vision 2040. Let's be practical, because tax does not operate in a vacuum. So I'd like to encourage you that our role is to enable and facilitate business. And if you're not mindful of the business and socioeconomic environment you're operating in, then you're doing yourselves a disservice, and you're also doing your clients a disservice. I think the second last point is around honesty, integrity. Recently, a colleague of mine at the tribunal was telling me they handled a matter, and the taxpayer, the lawyer told us that the client was sick. They couldn't come for conferencing because the client had been sick for 3 weeks. Lo and behold, you walk into town an hour later and you find this person very alive and very not on a sick bed, not in a hospital. And you're asking them, oh, how are you? What's happening? The person said, no, I'm not sick. Really? You haven't been sick for the last 3 weeks? No, I'm very, So that really it completely kills your credibility. Because the next time you appear before us, we'll not take you seriously. And we're probably going to get to a point where we begin asking for doctor's notes or sick notes, because the dishonesty and the lies really are not good. But also, I think it's important that when you have a matter, you're fighting fervently for your position, you're fighting for your taxpayer, for your clients, then you are also fighting for themselves. But at the end of the day, you need to remember that there's a dispute that has to be resolved. And this dispute has to be resolved fairly and equitably. So sometimes you need to step out of that element and put yourself in the shoes of the other person. If you're the URA, put yourself in the shoes of the taxpayer. If you're the taxpayer, put yourself in the shoes of the URA. Look at the dispute through a different lens. Don't come with everything cast in stone, because then that ends up derailing the dispute resolution process. Put aside egos. If you have a bad case, and we have hinted at you that, your case is not really that, put aside the ego and accept that your case is bad. Don't pursue it only to get the outcome that you probably know, but because I don't know how much you build your client or how much you're expecting, you have run through with this case despite knowing that it is a bad case. If there's an opportunity for you to settle the matter, do it at the earliest possible time and not have to litigate the matter all the way through. I think, Ian, that's it for now.
Thank you, Madam Chair. I'm still with you. You've spoken about the other side of the bench. Generally, what do you think would be a reform in a general tax dispute space? Do you have any points generally on the tax dispute space?
Reforms for tax dispute resolution?
Yes.
I think we can't talk about reforming the tax dispute resolution space without talking about cause, because a dispute is a symptom of an underlying issue. Whether it be a tax dispute, whether it is a domestic or marital dispute, there's usually cause and effect. So reform has to always begin with the underlying cause of the dispute. And with all disputes, cause is usually as a result of a breakdown of trust between two parties. So in this case, the parties we have are the Revenue Authority and the taxpayers. So as actors in this system, we have to ask ourselves that important question of why has the trust broken down? And what can we do as tax practitioners, as taxpayers, as the URA to build this trust? I'm sure the answers to those questions are in this room and online. So cause of the cause of the breakdown of the relationship must be addressed. But when you get into the process of dispute resolution, you begin, let's say you're beginning from audit stage. When you look at the audit, what I've realized from where I sit is that audit procedures and outcomes are not properly documented from the word go. Even record keeping on the audit end, just like taxpayers have challenges with record keeping, even the URA could improve on its record keeping. For example, someone comes to a tribunal and say, oh, the supervisor left or has been transferred. And then we have to start again from zero because there's no handover process. There was no proper record keeping. The taxpayer has to resubmit the documentation. So there is need to ensure that we are documenting audit procedures and outcomes from the word go. Then when it comes to information provision, there must be, I think there's need for us to introduce a system where an electronic or automated system to avoid duplication of activity. You find that information is provided at audit stage, and then when you get to objections, the objections team will ask you for the same information which you provided at audit. When you come to the tribunal, we ask you provide the same information you provided at objections. When you go to ADR, it's duplication, and this creates significant inefficiencies in the process. So it would be nice for us to have a system, an integrated system, where once information is provided at audit, then the person in objections has visibility of what was provided. And perhaps further down the line, it will also be nice when TAT also has visibility of what was provided at objections and not have all this duplicated. Timelines. When you look at the typical time a dispute takes, auditing, the audit period alone can take, if you're lucky, an audit will take 3 years. How many years does an audit take?
Well, here we did one which took short.
Which one?
There was one which took 6 months.
6
and 1
months?
year. Yeah.
But
Last
average
year.
time?
We are coming away from that.
Yeah, you're coming away? But average time an audit takes is what? 3 years, if you're lucky. If it's transfer pricing, it will take 5 years. Then objections. Then there's ADR. So you find that you spent 10 years in a dispute. Guys, that is not commercial. So we need to reduce the time that the dispute resolution process takes. So perhaps now is the time for us to introduce timelines. How long should an audit take? How long should, I know, Ms. Donovan, you mentioned ADR has no statutory deadlines, but how long should a matter spend in ADR? Because with each additional process, you're adding more layers to the dispute resolution process. And then looking at the profile. Sorry, do I still have time? 2 minutes? Okay. Or do you want me to deal with it later? Okay. Now let me hand over to Mr. Mutiwa.
Thank you very much, Madam Chair. Sorry for cutting your time short. Time is fast spent, and we want to dive into the real meat. Mr. Birungi is ready to give us some of these particular things that have disturbed tax litigators recently. Mr. Birungi, over to you on the issues of stay of execution pending appeal and the issue of 30%. I think we've seen decisions that have been controversial in this, and taxpayers and tax litigators are up in arms. I would like to pick your mind on what your view is, without crossing the sub judice rule, what your view is on the stay of execution pending appeals, because the jury is still out there. Mr. Birungi, over to you.
Thank you, Ian. I'm not sure what you mean by the jury results there, because with the open decision of the Supreme Court, I'm not sure what is still outstanding. The 30% is there fixed. There was a decision of FuelX which confused a lot of people to the effect that the 30% requirement could have been waived, and that wasn't a very helpful decision. I think you agree with me. But the requirement for stay of execution, of course, depends on who wants the stay. But at the tax tribunal stage, it is always the taxpayer who wants the stay, because it is the taxman following the taxpayer. And the taxman has raised an assessment, and the taxpayer is saying, I'm appealing, please don't collect everything. So whereas there is a 30% requirement to be paid, which appears kind of settled right now, it's important to note that the law was amended to the effect that even the other 70% can be pursued by the URA. So when the taxpayer is seeking a stay, most likely he or she is seeking a stay of the 100%. There is a 30% requirement to be paid, but there is nothing stopping the URA from collecting the 70%. So most of the time when you are going to the tribunal, you are looking at staying the 70%. You are also looking at paying the 30% and possibly paying that 30% in installments. So there is quite some process in explaining to the taxpayer, or a client for that matter, if you represent a client, that the 30% requirement was not waived by the FuelX decision. And number two, that there is still a risk of the 70% if you have paid the 30%, which is in the Section 15 of the Tax Appeals Tribunal Act. So at that stage, you need a stay in the tribunal. That is normally rather straightforward. What is a bit more confusing is if you lose a case in the tribunal and you appeal and you paid the 30% and you go to the High Court, and the dispute is whether you need to now get a stay at the High Court for the rest of the tax. So you had a stay at the Tax Appeals Tribunal, which expired after the decision of the Tax Appeals Tribunal. In other words, if the URA won the case, they can now follow up either the 100% or the new 30%. So there has been a dispute as to whether at the High Court you need a stay under the rules of the High Court under the Civil Procedure Act, what was Order 43, which says that the stay is granted on certain conditions, about 4 of them, that the matter may not be rendered nugatory, that the appeal has been in time, and about 4 conditions. And yet, the Tax Appeals Tribunal Act has its own conditions in section 28 and 29. So what is interesting is to note that the High Court judges have taken different positions. In one case, for example, in the recent Vivo case, you find that the judge said that the Civil Procedure Act doesn't apply, and it is purely the Tax Appeals Tribunal. We got a problem. Are you hearing me now? So at the High Court, for example, in the Vivo case, Vivo Energy versus Commissioner General, the judge said that it is the mandate of the court of the Tax Appeals Tribunal to secure the effectiveness of the proceedings and determination of application or appeal. It is not about the merits of the likelihood or the likelihood of success of appeal on the grounds of appeal. So there has been a difference between that and another decision, for example, in the Elma case, Elma Philanthropies versus URA, where Honorable Justice Duncan Gaswaga decided that it is the Civil Procedure Act that the judge has the discretion under the Civil Procedure Act and the Civil Procedure Rules to, under Order 43, use the principles which guide execution. And in that case, His Lordship decided that in addition to the 30% which had been paid at the tribunal stage, there was a 50% requirement to be paid. The judge said that before pursuing the appeal, the applicant should deposit a sum of 421,744, 50% of the decretal sum in the court as a condition for appeal. So you find that there is a difference between the two approaches by the same court, but it is also important to note that sometimes that decision is because the application for stay may have been made under the CPR rather than the Tax Appeals Tribunal Act. Much as the judge in the High Court should have the discretion to advise counsel if they have followed the wrong procedure, but if you have actually appealed under a wrong procedure, there is a bigger likelihood that the judge will apply the CPA rather than the Tax Appeals Tribunal Act in granting you a stay. So this is an area which is fairly controversial, and one wonders if one appealed then to the Court of Appeal or the Supreme Court, and each of those courts decided that you should give a different security for costs, what would happen? It would mean that effectively you are paying more than 100%. But it is also important to note that at High Court level, and increasingly so these days, the URA might be the one seeking the stay because it could have lost the case and is saying they should not refund. Of course, their situation is a bit different because even if you have won, you'll find that what is happening in practice, if the URA has lost a matter, it will simply put in a notice of appeal. And with that notice, they will say that they are not refunding because they are appealing the decision. And normally, this practice is not well documented. You simply put in a refund claim and nothing happens. And of course, that is quite unfortunate, especially when you look at some of the way the law is coached, that your interest starts to arise from the time after the decision of court. So when you have a situation where you won at the Tax Appeals Tribunal and you have been there for 3-4 years, as the chairperson has said, and the law is saying that the interest you could get on your 30% starts to count after the decision of the tribunal, you have definitely been hard done by, which is quite unfair. So there are areas in the stay process which are unclear to the taxpayers and also not harmonious at the High Court level and beyond. Over to you, Ian.
Thank you, Mr. Virunje. The issue of the jury still there was on appeal, 30% after you've paid 30% or 40 or 50%, but you've dealt with it very well, and I think that's something that needs to be looked into. Our time is fast spent. I'll have a last round of questions to our panelists, and it's on basically on the reforms that you would think. I'll give each one 2 minutes to answer. We'll start off with Ms. Donovan. On the ADR practice, what do you think needs to be reformed in that practice so that it can work better?
Thank you very much. One of the key things that would really help in the ADR process, or in terms of the dispute handling, listening to the other panelists here today, is clearly the need for automation of our systems and processes, because one, that would solve issues of where the information is. If we have automated processes right from the start of the appeal, when the person disputes, and all the evidence is really on a file system, and we walk the similar journey, so the evidence that is provided is not in dispute. If we have that sorted, at the moment we are working hard to make sure that the ADR process is also automated, which would give us visibility so that we're not simply relying on reports, but also to give comfort where matters come into dispute and people are saying they submitted, but there's no evidence of that, and such not. So automation is really critical. It is something that we're really working hard on. I'm sure you're all aware that as an institution, we've really worked hard to automate systems, and we have done the scoping for the ADR. So hopefully we're getting to the place where the entire system is automated, and therefore the evidence and information is readily available at all times. And so that taxpayers are equally not frustrated where they say, well, we already provided this information, that we shouldn't put them in that position because they're already aggrieved. But the other matter really is we need to rethink our processes. Currently, you have 7 days to go to ADR. Now, that 7-day time frame did not really provide for exceptions. And whilst we have been very good at using discretion to provide exceptional circumstances, we really need to embed that into the law. Because as it stands, if we know that you have the taxpayer is going to pay a certain tax based on the objection decision, but clearly there's evidence that says that tax should not arise. The instances, for instance, where someone has said that actually they were exempted, so the tax should not have arisen, but they did not have the evidence, and they eventually get that evidence rather late, past the times of the objections and all that. And then the reality is that person, there's no court that will adjudicate and say you still have to pay, because, even if it's basing on a technicality. URA officers are equally not robotic in nature, they are human, and we know that that will not fly. So we need to amend the regulations to provide for that process where the exceptions based on evidence are provided for. I know one of the sticking issues is that 30%, it's a very dangerous area even for me to mention as URA. But one of the things that is, the law indicates installment payments under exceptional circumstances. And there are instances where, say, in an instance, the person has gone to the court, but we know that that tax is not going to be paid. What we're working on at the moment is we simply expedite the review process for that matter. But we should provide a system where things are fair for all. What is due to be paid has to be paid, no doubt about that. But instances where it doesn't make any logical sense, the law should really provide for those provisions so that it's not seen as a matter of discretion or high-handedness where the facts really don't speak to the matter. The other key thing would be to actually resolve our systems. We did, as URA, we did benchmarking visits to Rwanda Revenue Authority and Her Majesty's Revenue and Customs Service, HMRC UK. And what was clear is they have very clear processes which are not conflicting. Currently, our ADR timeframes and the TAT timeframes create a level of conflict where you have people at ADR, and then because they're worried they're going to run out of time, they go and file an application at TAT. Then they're in a situation where they have to pay the 30% deposit. And then maybe ADR decides that actually we can't be handling it in two different places because it's a waste of resources. What would help, based on what we saw happening in the UK, the system is such that if you're under review, that would, in a sense, would stop the time. But it would require that there's a timeline for ADR so that you have to finish the ADR process before you have to go to TAT. And that would solve the issue. So we do need to really amend our regulations to provide for our life situations, to provide for areas like the sensitization that we need to do, because anybody, literally anybody in business can end up with a dispute and they may have to object. But if they are not aware of the regulations, they are literally having the headache of a huge liability, which could be resolved if they were aware of what needs to happen. So we need to have that sensitivity to our taxpayers. And I suppose really from our perspective, as taxpayers, I think we're really trying to work hard to be client-centric so that we're not simply, I know the taxman will never be loved by anybody, but at the very least, we can all know that and treat people as human. And therefore, one of the key things is even for us as the people who are raising these assessments, who are dealing with these disputes, to try and have a day in the shoes of the business person so we can understand their business, because as URA, we cannot exist without the taxpayer. We cannot exist without all the different people involved, all the panelists, the practitioners, the courts, all those are key relevant stakeholders. And we somehow need to harmonize and work together so that the country can develop, because we need the revenue. Equally, we should not kill businesses, and we need to have that balance. That can be resolved through reforms and the law reform to make sure we have a framework that caters for the situations we have, and is not seen as URA being high-handed, but is seen as these are the rules and this is how it works. And we've sensitized people and translated all these regulations into the local languages and dialect, which the local businessman can understand. Thank you.
Thank you, Madam Chokunda. Madam Chairperson, parting shots. I'll give you 2 minutes as well.
All right, thank you, Ian. I think I'd like to reiterate our commitment as the Tax Appeals Tribunal to helping both parties, taxpayers and the Revenue Authority, to resolve disputes quickly, efficiently, and fairly. And but that we can't do that alone by ourselves. We have to all work together to ensure that each one is playing their part in building a more fair and just and equitable tax system. Because at the end of the day, taxation is not the reason for our existence, all of us here. It is business, it's trade, it is commerce, and our role as actors in this system is to be enablers and facilitators of trade, of commerce, and of industry. And therefore, it's important that we come to the table with clean hands, we come to the table from a fair perspective, because when I look at the disputes that we have before the tribunal, I'd say 50% of them shouldn't be with us. If somebody down the line had done their job, had taken their role seriously, and understood that they are supposed to facilitate a taxpayer, to facilitate trade, to facilitate industry, then that dispute wouldn't escalate to ADR, to escalate even to objections. It wouldn't even come to the tribunal. So my urge and appeal to all of us, the tax practitioners, the lawyers, we all have a role to play in ensuring that we're actually building a tax system that is fair, that is just. So when your client has a liability and you know that it's due and payable, don't come to TAT, don't even go to objections. Tell them you have to pay this tax. Don't clog the system. In the same vein, if the taxpayer is compliant, don't assess for the sake of collection or for the sake of hitting a target. So it all comes down to each one of us playing our part fairly and equitably. Thank you.
Thank you, Madam Chair. Mr. Birungi, your parting shot, sir.
Thank you, Chair. I want to start from where the chairperson of the tribunal stopped about some action by the URA of late. I think most practitioners experience demands either about provisional tax. Just today, as I was on this panel, somebody is saying we are not giving you a tax credit certificate, a tax clearance certificate, because your provisional tax return is zero. I find some of those are not really in the law, but they are practices which very much affect the people, and they reflect they give an impression that URA is really after the money rather than anything. Basically, the tax exemptions which were granted or which are under review at the end of last year have been as if they were for sale. Taxpayers were told, unless you pay this amount, you are not getting a clearance. I hope Donovan got this feedback, but it is unfortunate. And I want also to go to reiterate what Donovan said about reforms, especially where she said in the ADR, there should be discretion. And I saw this discretion going to the 30% rule. The 30% rule is fixed currently, and it is unreasonable in many cases. The government says we want the money, but it's also obvious that there is room for you to get that money, even without the 30% rule. Originally, the law was such that if you paid 30%, you were automatically protected. Right now, you are not automatically protected. So you could still get that money with or without that rule, without the UPMAC decision. So I still think this rule needs to be reviewed and should be part of the reforms. But the ADR rules themselves, when you go for ADR, first of all, as the commissioner said, 7 days are very unreasonable, even with a straightforward case. Very unreasonable to hope to resolve the matter, to appeal in 7 days. For many people, they will not even have known what to do about it. So that timeline is important. But when you go for ADR, then they tell you, oh, this cannot be done at ADR. This is in TID. It is not handled by ADR. This is in legal. It's not handled by ADR. the ADR rules themselves, when you look at them talking about conciliation, mediation, you are like, is this just theory or what? They are very unrealistic. They are not on the ground. So since the commissioner responsible for law reform appreciates that there is need for review, I think it's the right time for her to call the stakeholders and brief us, and we discuss what they found in Rwanda, what they found in UK, and we have meaningful reforms, not those which are initiated from one side. Also, as you may note, we have an appeal system up to the Supreme Court. But you wonder, why would you need leave of the Supreme Court to appeal? If you are appealing on points of law, I think it should be automatic. Either you have a good case, and you don't have to prove to the Supreme Court that you have a good case. The idea of seeking leave itself is so time-consuming and unnecessary, should be dropped. When you look at the timelines for appeal, and it says you appeal to TAT in 30 days, or you can, for good reason, extend to 6 months, and then you have a decision of the High Court saying this 6 months rule can be interpreted differently in the Farid Megani case. There are many areas there are things which clog the appeal process, which are unnecessary. If I need to prove why I should have appealed in 6 months, why can't it be straightforward and you allow people to appeal? Because by the time you have 20% of the cases simply appealing to be allowed to appeal, you are creating a clog in the system. So I think those reforms, if they come in, we shall be able to move forward. But I wish to appreciate the panelists and the efforts of the tribunal, which are very commendable, and the reforms which are proposed by the URA. I hope we shall be involved in the reform process. I thank you.
To my panelists, members present, those online, thank you for tuning in. We've come to an end of our panel discussion. As I said, I have the privilege of being the only person asking questions. But before I take leave, I'd like to recognize the presence of notable tax practitioners in the room. Mr. Joseph Okuja from Libra Advocates, Festus Akunobera from ABMAC, Dennis Kakembo from Crystal Advocates, Vanessa Mbekeka from AF Mpanga, Bruno Kalibala from Grant Thornton, Mr. Kule Roland from SM & Co, Tony Kalunji from URA, Prida Diana from the URA, their presence with us in the room, and many other people also. Thank you very much for joining us. Thank you very much for my panel for keeping time and for answering these questions that have been put to you very ably. I've been your moderator for the day, Ian Mutibwa, partner SM & Co, and I would like the discussion to continue even after we close here. But thank you very much for tuning in, and I would like to hand over to the next moderator for the next panel. Thank you very much. I would like to remind those who are present in the room that there's a QR code in front of you. You need to scan it and register your details for purposes of the CLEs. Please scan the code, then register your details. The code is right in front of you. Thank you.
Yes, please. Apologies for that technical glitch. Once again, good morning, everyone. Those appearing physically here and our colleagues online, thank you for taking time off your busy schedules to make it for this year's Tax Law Symposium. My name is Bruno Kalibala, and I will be moderating the panel discussion regarding recent trends in capital gains taxation in Uganda. The discussion will focus on 4 hotspots, and those are taxation of indirect sale of shares in Ugandan companies, land disposals, rollover relief in regards to reorganizations and asset share exchanges. We will also look at withholding tax on sale of mortgaged property. And to unpack all this is a panel of 3 distinguished tax practitioners. On my immediate right is Mr. Dennis Kakembo, who is a distinguished lawyer and chartered accountant with over 17 years of experience in tax practice, specializing in fiscal regimes for energy and extractives, and he routinely advises on cross-border structuring, dispute resolution, and regulatory compliance. He is a co-founder and the current managing partner of Crystal Advocates. Mr. Dennis Kakembo, you are welcome. In the middle is Mr. Tony Karungi. He's an advocate of the Courts of Judicature in Uganda and currently serves as the acting manager, appeals litigation at the Uganda Revenue Authority. He's an international tax affiliate with over 10 years of experience in law and tax practice. Mr. Tony, you're welcome.
Thank you, Bruno.
And then last but not least is Mr. Joseph Okuja, a man who needs no introduction. He's an experienced tax practitioner with over 25 years of experience in tax law and practice, and part of those 25 years were with Uganda Revenue Authority. So he used to raise those assessments that he now challenges on a daily. He's currently a tax consultant in the private space with Libra Advocates and Consultants. He's an author and publisher of tax literature and commands vast knowledge and experience in tax law, practice, and policy issues. Ladies and gentlemen, that is our panel for the discussion. We will have a brief question and answer session at the end of the discussion. And for those appearing online, you may post your questions in the chat. We will take time to look at them. And to start the discussion right away in regards to taxation of indirect share transfers, Mr. Dennis Kakembo, what is the taxation framework for shares, for sale of shares that are indirectly dispose of stakes in Ugandan companies?
Thanks, Bruno. Thanks our viewers and everyone who is physically attending this tax symposium. The question you've posed is one that has elicited quite a discussion recently in Uganda. But it's not only an issue that has only arisen in Uganda. In fact, Uganda joined the party late. It's only that, even though we joined the party late, it appears like our provisions have incidentally raised the most controversy. My first time to interact with indirect disposals was in 2012 when Tanzania amended its Income Tax Act and introduced a provision that is quite similar to what we have in Section 74 and 78 of the Income Tax Act. To the best of my knowledge, much as it is there within the law, there has only been one case, and that was the case of when BG was acquired by Shell. There was a big dispute regarding how valuation would be conducted, whether CGT would arise, and I don't think that dispute has ever been resolved with finality to date. So that notwithstanding, that provision being in the law of Tanzania, I think they are pushing not so aggressively as we are seeing happen in Uganda. Then Kenya joined the fray, and I think they joined the fray in 2015. Their principal focus was on the extractives. They introduced a provision which is not exactly similar to ours, but the principle is largely the same. And I think it treats to the effect that if there's a disposal of an interest deriving from extractive industry, whether directly or indirectly, Kenya has a right to tax. It's only that for it apportions if, actually I think Kenya's provision, like our section 78H, as I'll go, 78G, as I'll go into it. So what happens in Kenya if the value attributable, the overall consideration outside, is deemed to contribute to at least less than 20% of the asset you have in Kenya, then Kenya doesn't tax it. But if it's between 20 to 50, then Kenya does a pro rata taxation. And if it's over 50%, Kenya will tax the entire provision, but rather the entire consideration accruing out of it. Of course, there have not been so many disputes. There's only one that I'm aware of. This was AFI. And how it arose, there's actually a possibility that we are also likely to have a replay of the same. Because the law talks about change in ownership. Now, in what happened in Kenya, AFI, River, I think, issued shares. So there was a dilution in ownership by reason of issuing of additional shares to recapitalize the company. And as a result of that, the tax authorities were arguing there's a change in control or change in ownership, and therefore they demanded for tax. Fortunately, it was dropped subsequently. Now, when we come to Uganda, in 2018, Uganda took a leap forward and amended Section 74 currently. I think then it was Section 75. And then also Section 78, which then was Section 79 on the source rule. Of course, when you try to appreciate what Uganda was trying to achieve, the rationales are justifiable. If you're deriving gains that relate to business operations or assets that are located within the country, it's only fair that Uganda should have a piece of pie. Despite the rationale being very clear, and being justifiable, the application and interpretation of those provisions has raised a lot of controversy. And personally, the view I take is that if URA looks at the same law, if the Attorney General of the country looks at the same law, if the Tax Appeals Tribunal looks at the same law, if Ministry of Finance looks at the same law, if tax practitioners look at the same law and they all draw different conclusions, it is not a thing about the tax practitioners, URA, or the tribunal. It's actually a thing about the law. It clearly explains or illustrates that there is a nudging point within the law for which we need to take a step back and probably give it consideration. Now, when you look at the 2018 amendment, it was to the effect that if there's a direct or indirect change in ownership of more than 50%, then there's a deemed disposal triggered in the company in which there has been a change in ownership. Of course, the biggest issues that are arising to date are valuation issues. And everyone has been taking a different approach, net asset valuation method. When you look at financial valuation, there are various methods of valuing a business. It could be discounted cash flow, it could be income multiples. But because the law is talking about you're deemed, if there's a change in ownership, you basically look at the assets and take their market value. Before the tribunal recently came out to guide on how that should be taken, everyone was taking a very different approach. And of course, I don't know whether if you speak to the URA, what the law really speaks to is what, in their view, is what the law intended to achieve. Because imagine a situation where I have disposed of an entity and I have got $100 million. Now, because I am asset light, when we come and do a market valuation of the assets on my balance sheet, you're probably arriving at 50 billion. How are you going to account for the difference? That difference could probably be explained by goodwill. But if you go by market valuation of assets which sit on the balance sheet, you cannot be able to determine that. And I think on the side of URA, even yourselves, URA, you should actually aggressively push for the law to be amended so that some of those issues are clearly catered for and looked at. Now, on the side of taxpayers, if you look at the recent tribunal position in the EnviroServe matter, it puts taxpayers in a very difficult position. So difficult that if I acquired assets using debt, if there's a deemed disposal, for as long as I still have the debt on my balance sheet, the debt is going to wipe off the cost base of the assets I have. And what will remain to be taxed is essentially the market value of the assets that you still have on your balance sheet. In fact, prior to that position, if you would engage with URA, a position which already taxpayers were aggrieved with, the URA position seemed to be more palatable, despite taxpayers finding it not that very fair to them. In illustration terms, chances are that if URA were to go back and revisit assessments for previous cases, they did, the tax liability could now rise like 3 times fold prior to the position URA was taking. But ultimately, without not delving further into the technical issues, I think there's a challenge. We all know very well the intervention of the Attorney General. The Attorney General has actually written a firm opinion and has advised URA that the position you're pursuing may not be sustainable at law. So I think we need to take a step back and re-evaluate, because as we speak now, quite a number of M&A transactions seem to be stalling. And equally so, in addition to that, just imagine if I sell off a holding company in Mauritius that has operations in Kenya, that has operations in Uganda, that has operations in Tanzania, who all seem to have the same law. It will mean Uganda will come and hive off whatever they consider to be part of the same transaction. Tanzania will also do the same. Kenya will also do the same. Previously, we've had challenges on if it's group consideration before the tribunal came in and guided on how the market valuation could be considered. If you disposed of, there was a transaction, a group level transaction, and you got maybe $200 million. Uganda Revenue Authority ultimately would want to see that the consideration allocated to Uganda fairly represents the economic activities in Uganda. Kenya Revenue Authority, if they were to take the same line, they would also aggressively push for a bigger allocation of that. Tanzania would also potentially push for a bigger allocation of that. So you end up having a taxpayer being taxed in 3 different countries. So I think at institutional level, we need to look beyond that. I know OECD and all those international bodies came up with these proposals, but some of those proposals, when you interrogate and look further into them, they are problematic. And then lastly, on that, when you look at our law, I don't know whether we thought about it, there's a rebasing. So if there's a change in ownership, essentially the assets and liabilities are stepped up to reflect the value at which they've been disposed. Now, a question which one would ask is that, does it mean that if there has been a deemed disposal for tax wear and tear purposes, in case the assets as a result of that transaction have been stepped up, are you going to claim wear and tear at that level, at the stepped up? So there are so many questions which need to be looked into. And then also, lastly, direct disposals. We are seeing upcoming approaches where URA is also stretching that provision of the law to apply to direct disposals. By direct disposals, we mean that you have a company like MTN or Airtel located here, and then you directly dispose of your shares in MTN or Airtel, Uganda, and then you even go to URSB and file a return. We are seeing approaches where URA is actually deeming the deemed disposal rule in relation to such transactions. Of course, it is not without thought. URA will tell you that when you look at the law, it talks about direct and indirect disposals. But then a question you'll ask is that when you go and look at Section 78 on the source rules, there are other provisions where, if it is a direct disposal, where such a transaction could fall. For example, when you look at Section 78G, if you're disposing of shares in a company principally made up of immovable property, that gives you a right to tax someone who directly disposes of shares in such a company locally. Now, supposing I fall under that provision, but then there has also been a change in ownership of more than 50%, and I'm a non-resident, or a resident, what provision should URA apply? And then I know I've been saying lastly, now this is the last on this. When you discuss with URA or even other players, the whole essence of that provision was to ensure that there is no tax leakage on such transactions. In fact, one will tell you that if you're to apply Section 78G and H, the result should give you the same. How you're taxing should give you the same. But in practice, it's not how it works. You place your transaction under Section 78H and 78G. The results will be totally different. And that should actually tell us that there is a problem in the law, and we would encourage the Ministry of Finance and URA. For the meantime, I know the numbers in these transactions are quite juicy and can significantly contribute to tax collections, but I think we need to first suspend implementation of that, clear the challenges around, and then move forward. Thank you.
Thank you so much, Mr. Dennis Kakembo. I'm glad that this time around the last was indeed the last. But before we move on to our next segment, I want us to recognize the presence of Ms. Stella Nyapendi Chombo, who is a member of the Tax Appeals Tribunal. She's here with us, and we are glad that she has taken time off her busy schedule to come and be here with us. Now, Mr. Tony, Mr. Kakembo speaks to a need for reform and a cautious approach in regards to the law on this particular area. But now we find ourselves in a position where we have to deal with the law the way it is as we await for reform. And in the recent past, Uganda Revenue Authority has been sending out information requests whenever it suspects that a transaction could fall within the relevant provisions of the law. For the taxpayers and the practitioners listening to us today, we would like to know what particular information is URA interested in.
Thank you, Bruno, for the question. Maybe before that question, we need to look at why the information is requested for. Now, first of all, this is an indirect disposal that has happened, probably offshore. Now, if you look at the cases URA has handled, the only information they get that triggers them, okay, for some companies there, let's say you see the New York Stock Exchange and you realize there's a change in ownership. The information they receive or they get or that triggers them to assess this tax is limited. They will only know that maybe a transaction is about to happen or it has already happened and it's probably offshore. So because of that, whereas the sections 78 and 74 provide for sourcing and taxing respectively, you realize that before you go directly to tax, you need further information, not from this taxpayer who will bear the final incident of tax, this taxpayer in Uganda, but you need information outside. And for that, that's how the request comes in. But now the law is not couched in a way that it requires specific information to be requested. For instance, as an example, if you look at, let's say, in issues of transfer pricing, you could have specific information that they require to be kept at premises of the taxpayer or to be filed continuously. But for this transaction that has just happened, the information is not provided for in those sections, but there are general laws that we rely on to ask information, and it will depend on the auditors. For some of the cases we have handled, some have even been settled. Broadly, they will begin with the structure of the group or the related parties. They will ask for that structure to be able to understand how far have the transactions gone. Now, after the structure, then they will come to the company, normally certified documents of the parties involved, if they are companies. If it's a company here, if it's either, whichever way, they request for that to understand in detail who probably bears the control and where the shares are moving from. Then you go to the transaction itself. They will ask transaction documents. Sales, most of the sales are not basic. Some people can sell, and then you find that the sale agreement comprises of other series of agreements. So all the transactions and allocation of the proceeds will be asked for. Then if you go to the issue that Dennis hinted on, and which is mostly, the most information they will require will be the valuations. Now in these transactions, it's not unusual for the purchaser and also the seller to have their valuations. They will ask for valuation reports. And when those are provided, normally they will have a basis to start from. But in the process of verifying and knowing the cost base and the assets, they go far as asking audited books of account. I've seen also cases where they require those to be certified. Sometimes they even ask for explanation. So the list is non-exhaustive, and it can be probably relating to the specific taxpayer or the transaction in issue. So that's normally the information that is requested. But all the information that is requested is pointing towards making sure that we are able to tax and get the proper value of the transaction in issue. Yes, thank you.
Thank you so much, Tony. And I think both Tony and Mr. Kakembo have hinted on the fact that many of the transactions that have raised concern in this particular area involved an offshore element. So that means we are likely dealing with transactions that have happened between companies that are resident in other jurisdictions other than Uganda. And on that point, I want to bring in Mr. Joseph Okuja. Assuming the parties, the principal players in the transactions are resident in a country perhaps with which Uganda has a double taxation agreement, how does the local legal framework interact with a double taxation framework in practice?
Thank you so much, Bruno. And thank you, Dennis, for the elaborate background you gave regarding the introduction of this particular law that targets indirect offshore transfers of shares, which, as Dennis indicated, is actually an effort that is noble because it was introduced to curtail tax avoidance of capital gains, especially by multinationals, who, instead of selling the assets that exist in a particular country, opt instead to sell shares, because you can avoid capital gains tax by, instead of selling the assets, you sell the shares. So there was a lacuna in the law regarding the sale of shares, especially offshore, because if it is domestic, then there are adequate provisions within the law that would ensure that the capital gains arising from such transfers is actually subjected to tax. But now, where multinationals are involved and shares are sold offshore, developing countries realized that they were losing out on quite a bit of revenue, in the sense that the capital gains that would have been subjected to tax in a country like Uganda is now avoided because shares have, rather, assets have not been sold, but instead shares have been sold in a different country. Now, this amendment that came in 2018, specifically in Uganda, is not unique to Uganda, like Dennis indicated. A number of African countries have adopted the same provisions, and this was really a multilateral effort because the OECD was involved, the World Bank was involved, the IMF was involved, and they came up with these recommendations. But of course, like all recommendations that come from multilateral discussions, there is always a caution that when implementing these recommendations in your countries, you must adapt them to the circumstances in your countries. Unfortunately, in our case, I think we are so used to copy and paste, and the challenge we are facing currently is because the original provision that was proposed at the multilateral level was merely copied and pasted in Uganda without having to make any modifications, taking into account our economic circumstances. Now, regarding the place that DTAs play in this whole saga, even at the multilateral level, it was recognized that these provisions would not be applicable in situations where a country has a double taxation agreement with another country where the share transfer takes place, unless an amendment is made to the double taxation agreement. So to go back to your question, the role that double taxation agreements play as regards this particular transaction is catered for in our domestic law, and DTAs are recognized as domestic law once they have been ratified by Cabinet. And under Section 88 of the Income Tax Act, a tax treaty, which is an international agreement entered into between the government of Uganda and the government of a foreign country, or governments of foreign countries, shall have effect as if the agreement was contained in this act. So once you have a DTA in place, the DTA assumes the force of law in Uganda, and it must be interpreted as if it was a law that was passed in Uganda. Now, what is a DTA? Basically, a DTA is a negotiated agreement between two states. And the purpose of the negotiation is really to avoid double taxation and ensure that a taxpayer pays tax only in one country and not in two countries. So that's the principal purpose of a double taxation agreement. The other purpose of a double taxation agreement, of course, is to facilitate exchange of information between the two countries, because when DTAs are negotiated, they are really looking at investment coming or flowing between the two countries. Unfortunately, of course, in our case, the DTAs that we have with most of the countries, the inflows are from outside to Uganda. It is rare to find a Ugandan investing, either in the UK, in the Netherlands, or Mauritius. So the purpose that a DTA serves is to protect the interests of the non-residents who are investing in your country. So when a DTA is signed, it has the force of law in Uganda, and the law is very clear that any discrepancy between the domestic law and the DTA will always take precedence. Now, in the case of indirect offshore transfers, you'll notice that in Uganda's case, the amendment was introduced in 2018. Now, most of the DTAs that we have were actually executed and came into force before 2018. And therefore, there was a need to have the DTAs amended to specifically cater for the right to tax indirect offshore transfers, which in the current DTAs is not provided for. Because the question about indirect offshore transfers is really about the definition of what amounts to immovable property and what amounts to movable property. And this is something that could have been done. I have previously heard that Uganda is renegotiating most of its DTAs. I don't know how far that has gone, but in as far as the DTAs as they currently exist have not been modified to take away the right to tax indirect offshore transfers from the country where the shares are sold to Uganda through a deeming provision, then one could argue that an attempt to assess an indirect offshore transfer on a taxpayer who comes from a country where there is a DTA with Uganda, then you may be deemed to be creating a treaty override. And yet, within the provisions under Section 88, a treaty override can only be allowed where there is a deliberate tax avoidance scheme undertaken by the parties to the transaction. So when you look at the DTAs, there are three considerations that we have to take into account. The first one is that as far as DTAs are concerned, if there is no provision in the domestic law that subjects a particular transaction to tax, then there is no need for you to look at a DTA. In this particular case, the deeming provision that were introduced in 2018 under Section 74(2) would be okay for multinational companies where Uganda does not have a DTA. Those provisions would be okay. But where there is a DTA, then you need to consider under the DTA which country has the right to tax gains from the sale of shares. Unfortunately, in most of the DTAs that Uganda has currently executed, the right to tax the gains from the sale of shares is given to the country where the shares are being sold. And that is something that as part of the amendments we are considering, probably we have to consider. Secondly, as far as the DTAs are concerned, we need to understand that as part of the scheme to avoid double taxation, when DTAs are being negotiated, the two countries either surrender a taxing right or retain a taxing right in respect to particular aspects of transactions. Currently, in all the DTAs that we have, the taxing right for gains arising from the sale of shares is given to the country where the shares are being sold. And therefore, when Uganda introduced Section 74.2 and Section 78G or H in 2018, what they did was really to expand their taxing right to be able to tax gains made from the sale of shares that did not take place in Uganda. And by doing that, they are basically violating the terms of the double taxation agreement with all the countries that Uganda has a DTA with. So as far as double taxation agreements are concerned, the application of this particular amendment on indirect offshore transfers requires that double taxation agreements have to be amended. And at the multilateral level, when it was being discussed, they actually proposed the actual terms or clauses to be inserted in the amendments. And the revised model DTAs, both the OECD model and the UN model, have a clause that specifically modifies the taxing rights within the DTAs, such that developing countries can now exercise their right to tax those proceeds because the right has been taken away from the country where the DTA, where the shares are actually sold. So that is as far as the DTAs are concerned. And clearly, as of now, because these provisions were introduced through deeming provisions, both Section 74.2 and Section 78H are deeming provisions. The deeming provision under Section 78H effectively took away a taxing right, which under the DTAs is granted to the country where the shares are sold. And that has been argued to be a treaty override. And that is where we stand as far as DTAs are concerned and the indirect offshore transfers. Thank you.
Thank you so much, Mr. Joseph Okuja, for that exhaustive overview regarding how the double taxation framework interacts with the relevant provisions under Ugandan law. And now turning to Mr. Dennis. Mr. Okuja has spoken about a suspect position from a DTA perspective and the local statutory perspective. You spoke about the need for reform, and combined, the picture painted is one of caution. And maybe from a practitioner's perspective, does the current trend require some changes in terms of how we look at pre-acquisition audits, tax gross-up provisions, and other deal structures?
Thanks, Bruno. In light of the deemed disposal provisions, being a transactional advisor to an MI and a transaction has become a little bit complicated. More so if you have a client who requires a clear answer. Because as it is, when you're advising on such a transaction or you're doing a number crunching, you're likely to come up with 5 different positions. This is what URA used to do before. This is what URA did 6 months ago. This is what the tribunal initially ruled should be the case. This is what the tribunal revised. This is what the AG is saying. So it's very uncertain. And out of abundance of caution, you just have to give 5 different positions. And equally so, you would sympathize with the acquiring shareholders more so where the selling shareholders are totally exiting, because you're exiting a company on which subsequent assessments are going to fall. So even when you need to have tax warrant provisions within the SPA, you're still going to operate on a very wide latitude of uncertainty. Yes.
Thank you so much, Mr. Dennis. And I would want us to move on to the next segment, which is capital gains regarding disposal of land. And in the recent past, we've seen a surge in URA assessments targeting capital gains arising from land disposals. And Mr. Tony, if you may allow to start us off on this particular point, at what point does land become a business asset?
Thank you so much. The question of capital gains on land is quite interesting and technical. But before I go into the details, maybe just to give an overview, that in Uganda we have a very limited capital gains regime scope, in the sense that the capital gains that we have in Uganda targets gains from the sale of business assets. Now, business assets have been defined in the Act, and when it comes to the taxation of capital gains, Section 18 excludes depreciable assets from the scope of capital gains taxation, and for obvious reasons, because in most cases, depreciable assets will not be sold at a profit. It's very rare that you'll find a depreciable asset being sold at a profit. So that leaves us with basically land and buildings, which then become subject to capital gains taxation in Uganda, because those are the two categories of assets or capital assets that actually appreciate in value. Why? The essence of capital gains is appreciation in value of an asset. And therefore, when an asset appreciates in value and it is disposed of, that profit, that gain that a person makes, then becomes subject to income taxation. We do not have a separate capital gains tax regime in Uganda. Any capital gain that is taxable is added to business income and is taxed as ordinary business income. So the question on whether, on what constitutes a business asset for capital gains purposes is quite straightforward in my view, although I have seen quite a number of the decisions that have attempted to expound on that particular fact. Now, a business asset is defined under Section 2 of the Income Tax Act to mean an asset that is used or held ready for use in a business of a person. Therefore, the question of whether an asset of a person is a business asset requires the determination of whether the person is carrying on a business. That is very, very critical. Now, a business is also defined under Section 2 of the Act. Once a business undertaking is established, then it means that every asset that is used or held ready for use in respect to that particular business activity becomes or qualifies as a business asset. Now, the definition of a business under the Act is an inclusive definition. That means it is very, very wide. It is defined to include a trade, a profession, a vocation, or an adventure in the nature of trade, which then becomes very, very wide. So in order for any person to determine whether an asset that is the subject of a business is actually a business asset and therefore subject to tax, requires one to examine whether the person is engaged in a business activity, first and foremost. Are you engaged in a trading activity? Are you selling and buying whatever it is that you are selling or buying? Are you in a profession and the tools you are using in your profession are part and parcel of what constitutes business to you? Have you undertaken a transaction that looks like a business transaction? That is what adventure in the nature of trade means. And of course, through a number of precedents from the UK, mostly, we have what we know as badges of trade that helps us to determine whether a particular activity undertaken by a person falls within the domain of a business activity. And once the determination of a business activity has been made, then any asset that that person is using or is holding to use in that particular activity qualifies as a business asset and therefore would be amenable to capital gains tax. So specifically on the question of land, one needs to consider a number of factors, okay? For example, when you sold the land, because the act of selling is a business activity, it is a commercial activity. When you sold the land, was there a profit motive? Because that is one of the indicators of a trading activity. Have you done it repetitively? Are you continuously buying and selling land? Okay. What is the size of the land that you're selling or trading in? Because if someone has, for example, acquired a 50 by 100 plot and you held it for 10 years and sold it at a profit as a one-off transaction, in my view, that would not constitute a business asset because it's a one-off. But if someone acquired 100 hectares of land, okay, held it for 10 years, and then decided to subdivide and sell, is that person, even if it is a one-off transaction, does that activity amount to a business? And that is where the whole concept of an adventure in the nature of trade comes into play. Because an adventure could be a one-off transaction that one has. But is it undertaken in such a way that one would consider it to be a business transaction? So those are the considerations that have to be taken into account in determining whether a particular transaction amounts to a business, and if it amounts to a business, then all the assets held or used in respect to that particular business would then qualify to be business assets. And if sold, would give rise to a taxable capital gain. But like I said, in respect to Uganda, capital gains would only apply to land and buildings because the other depreciable assets are taxed under a separate regime. Thank you.
Thank you so much, Mr. Kuja. I would now want to move on to Mr. Tony and to continue the discussion on business assets. The law was amended sometime back around 2021 to introduce indexation of cost bases. What exactly does indexation entail, and what are some of the common challenges you have encountered in practice? Mr. Tony.
Well, yes, essentially before, there are aspects of inflation that come into play. So before you compute capital gains tax, you need to take that into consideration. So it was essentially brought up to allow for that aspect to be taken into account. And there's a formula provided for, so as long as there are consumer price indices that are there, you need to take them into account before you tax someone. And we have seen cases where the tribunal has faulted URA for not taking indexation into account, and we have complied. And I think the issue is, as you have talked about it, the fact that it came into 2021, it could be that maybe because of time, people have not yet appraised themselves with the provision. But that would be the only challenge I'm seeing. Then there's an aspect of the fact that the formula will provide for things to take into account, but taxpayers might not have access to these consumer price indices. Where will they get them? So there are those issues. But if those are addressed and there's stakeholder relationship and information is put out there, we'll see to it that while computing capital gains tax, these are aspects that will be taken into account to remove inflation, basically.
Thank you so much, Mr. Tony. Maybe going back to Mr. Joseph, in practice, Mr. Tony has spoken about limited access to the consumer price indices. In practice, how is this addressed?
The responsibility to publish consumer price indices, I think, lies with the Uganda Bureau of Statistics. And to the best of my knowledge, I think they produce those indices on a monthly basis. And also, to the best of my knowledge, URA has those indices, because I have previously requested them to provide it to me, and they have given me those indices. Because sometimes it's difficult to get it directly from UBOS. And even if you got it from UBOS, you may have a challenge with the URA team, because they prefer to rely on theirs. They believe that any other indices, even if you say you got it from UBOS, unless probably it is certified, they will normally prefer to rely on theirs, which is given to them. But the indices are available, and there is no reason as to why URA should not be using those indices to actually inflate or increase the cost base of the assets, which then has the effect of reducing the gain that would be taxable as capital gains. So that's the purpose of indexation, because over time, the value of assets increase. And because of inflation, the original cost at which an asset was acquired cannot be the same. If the original cost is maintained, then at the time an asset is sold, it means that the capital gain would be inflated. And that was a challenge that was being faced by most taxpayers, especially those that were dealing in land. It was common, especially in Kololo, where probably at the time this particular Indian acquired that land, it was costing 1,000 shillings. And now he's selling the same plot of land at 5 billion shillings. So in such a case, the difference between 5 billion and 1,000 shillings would be the capital gain, which would be subject to tax. But with tax indexation that was introduced in 2021, was it 2021? Yes. The effect it has is to uplift the cost base of the asset, to take into account inflation, such that the capital gain that is realized when an asset is transferred at the current point in time is much lower and therefore manageable by those who are selling their properties. So in practice, the indices are there and they can actually be used. Thank you.
Thank you so much, Mr. Joseph, for that clarification. Now, moving on to Mr. Dennis, as a legal practitioner, you must be aware that part of the routine engagements lawyers take on is to manage estates of deceased persons. And in many times, advocates find themselves in a position where they have to dispose of estate property as part of the estate distribution frameworks. Are there any capital gains considerations that should be taken into account? Many of the lawyers undertaking these assignments are probably not tax specialists, and they would want to know if there are any capital gains considerations.
Thank you so much. Of course, the fact that URA has not been aggressively pursuing that does not mean that the law does not cater for that. And the sooner we appraise ourselves with it, the better, so that when URA is coming after us, we don't accuse it of interfering with our cultural rights and the kind. But if you, as an executor or administrator of the estate of the deceased, you are to distribute assets directly to the beneficiaries, there's no capital gain tax implication. It's a nil gain, nil loss. The law fully caters for that. But if you were to dispose it off to a third party and then account for the proceeds to the beneficiaries, there is an implication, and that implication can be found in the provisions of the law relating to the taxation of trusts. If you're disposing of such and any income has been derived, URA has a leeway of either going after the beneficiary or going after you, the administrator. So it's important that we appreciate and understand that. In terms of how incomes are determined, this will be if basically capital gains provisions would apply, if there's also VAT that could potentially arise, you might also find yourself having to charge VAT. Of course, taxation of trusts, I mean, I've practiced tax for 17 years, and this is not a matter you routinely interface with. So if you have a situation like that, it might make a lot of sense for you to come and interface with URA to see whether you can use your TIN or whether there can be a special TIN, or whether the beneficiaries, if they're selling jointly, they can have a TIN. That's all I can say.
Thank you so much, Mr. Dennis. And now moving on to our next segment, which is rollover relief, specifically for asset share exchanges. Mr. Joseph, what does this entail, and does it require that the consideration for the transaction is limited to the cost base of the assets that are being transferred?
Thank you, Bruno. I just want to make some small clarification. Now, as far as capital gains taxation is concerned, as long as there is a disposal of a business asset, there will be a capital gain, which is taxable. Okay? So the key term there is disposal, and the term disposal is defined very widely under the Act, and it covers all transactions where there is either a change in ownership of the asset or a change in the beneficial ownership of a particular asset. That amounts to a disposal, and automatically that will give rise to a capital gain. However, the law, of course, recognizes that there are certain transactions that should not be subjected to capital gains. In fact, if every asset transfer was subjected to capital gains taxation, I think it would be very, very cumbersome for businesses to sustain their activities. So the law specifically has provisions that either exempt or defer the payment of capital gains to a subsequent transaction. And that is what is called rollover relief. Rollover relief basically means that a transaction has taken place, that transaction gives rise to a capital gain, but because there are specific considerations under the law, at the time the transaction takes place, that transaction will not be subject to capital gains, but the capital gains taxation may come at a later stage if that asset is sold again. So that is basically what rollover relief is all about. Now, under the law, there are basically 4 situations where rollover relief is granted. The first one is asset transfers between spouses who are divorcing. So if you're husband and wife and you decide to divorce and you have to share the assets, in most cases we're looking at land and buildings. Because the sharing of the assets amounts to a transfer or a disposal of those assets, capital gains would arise. And in the wisdom of the legislature, it would be very unfair to subject a husband or a wife to capital gains tax because they have divorced in the first place, and now you want them again to pay capital gains tax upon transferring the assets between themselves. So the law grants a rollover relief in the sense that the cost base of those assets is rolled over to the next transaction either by the wife or the husband. So if the property has been split between the two and then subsequently the husband decides to sell the house, that is the point at which capital gains will become applicable. But during the separation itself, the capital gains is rolled over and you will not be subjected to tax. The other situation is where there is testamentary transfers, and this is where the transfer of assets are made to a trustee or to a beneficiary. Okay? In that case, the law also recognizes that because somebody has died and has left assets either to a trust or to beneficiaries, it is unfair at that point in time to subject the trust or the beneficiaries to a capital gains tax, because in most cases anyway they will not have the money to pay. Okay? So the cost base of those assets is rolled over to the next transaction that either the trust or the beneficiaries will undertake. And that is when the capital gains will become payable. The third scenario is where there is an involuntary disposal and reinvestment of the proceeds. So if you are forced to dispose of your capital assets, okay, the law is giving you relief by saying, if, say for example, government came and took over your land and compensated you, that action of taking over your land amounts to a transfer or a disposal, and therefore gives rise to a capital gain. But you're not going to pay capital gains tax because the law is giving you a relief. You have been forced to sell your land, and therefore the rollover, rather the cost base of that asset is rolled over to the subsequent transaction where you sell the replacement asset that you'd have acquired from the proceeds of that disposal. And lastly, of course, rollover relief is also granted where there are corporate reorganizations. Now, coming specifically to your question, you asked about the transfer of assets.
Yes, transfer of assets in exchange for shares.
In exchange for shares. So the law, of course, recognizes that you can acquire, you can make a capital contribution through assets as opposed to giving in money. Now, once an asset is moved from one person to another, that is from this particular person, an individual, a company, to the other company where you are actually going to acquire shares, then the law gives you relief from capital gains taxation. But there are conditions that must be met. To qualify for rollover relief where you acquire shares using assets, the following conditions must be met. Number one, the asset must be a business asset of the transferor. If it is not a business asset and you are using it to acquire shares in a company, you are not going to be relieved from capital gains. You will pay capital gains tax. The asset must be a business asset of the transferor immediately before the transfer. Why? This ensures that the deferral rule only applies to an asset that would otherwise have been taxable to the transferor. That's the first condition. The asset must be a business asset. Secondly, both the transferor and the transferee must be resident persons at the time of the transfer. If you are non-resident, then you will not qualify for a rollover relief. This condition ensures that the deferral rule cannot be used by taxpayers to take a taxable asset outside the tax base. Okay? So if any of the parties, either the transferor or the transferee, is non-resident, then they will not qualify for rollover relief when they use assets to acquire shares in a company. And then number three, the transferee company must not be an exempt organization, because if you're acquiring shares in an exempt organization, then you are taking that asset outside the tax base, and therefore the law will not grant you a rollover relief. You will have to pay capital gains tax at the time the asset is actually used to acquire shares in a company. And fourthly, the asset should be transferred to the transferee company in return for shares in the company. Okay. If the assets are not being given in return for shares, then you will not qualify for rollover relief. And finally, the transferor must have a 50% or greater interest in the voting power of the transferee company immediately after the transfer. So the most important point to note with rollover relief is that it applies where, number one, there is continuity of ownership of the asset, and two, there is continuity in the business or the purpose for which the asset has been used. Once you meet those two conditions, then you'll most likely be entitled to a rollover relief. But if there is no continuity in business, or if there's no continuity in ownership, then you'll not be entitled to a rollover relief. But it is available, and that is the rule that applies to all corporate reorganizations. There must be a continuity in ownership and a continuity in business activity as far as that particular asset is concerned, in order for you to enjoy a rollover relief. Thank you.
Thank you so much, Mr. Joseph. Coming to you, Tony, one of the conditions that Mr. Okuja has discussed is that the asset has to be transferred in exchange for shares. does that mean that the shares acquired in exchange for the asset, must their value be equal to the cost base, or the shares can actually reflect the fair market value of the asset? Mr. Tony.
Yes, thank you for that. Now, this calls for an interplay of two regimes. There will be tax, but then there will also be corporate and commercial. Ideally, if there is a transfer and you're going to lodge it, let's say at the company registry, they would expect on that share stock transfer forms for. Normally, I think currently URSB even request you for a valuation report from an auditor, and they would require you to indicate that particular value, which then they use to compute stamp duty, and they do the transfer. So it's taken as if there a fair market value would be used. However, when it comes to rollover relief, since ideally behind the doors nothing has really exchanged in terms of finance, therefore it would follow that with due respect to the fair market value, which is used for other purposes, when it comes to the interplay in tax, we have to take the cost base. We are not concerned as to the actual value. We use the cost base in the land. It's repetitively captured. Cost base, cost base, cost base. If we are to use the fair market value, it would bring into play issues of, normally these parties are related parties. So issues of rigorously questioning this transaction, whether it's at arm's length, would come into play. Then it will bring into issues of, let's say, even tax avoidance. They would question and say, why is it that these two people that are related are trying to transact this one? They will continue. So to avoid all of that, and even the idea that you're trying to avoid the disposal per se, you use the cost base.
Thank you so much, Tony. And now moving on to our last segment, which is withholding tax on mortgage property. And I'll start with Mr. Dennis. Just recently, I think last week or 2 weeks back, a decision by Justice Mubiru in Bernard Byamukama versus Paul Muanga came out. And in that decision, the land judge declined to follow Lualua Investments as far as withholding tax on the sale of mortgage property is concerned, which now means that we have 2 High Court decisions pulling in opposite directions. What's your sense of the 2 decisions, and is there a way of reconciling the 2?
Thanks so much, Bruno. Now, first and foremost, I have an observation to make. I think in the last 5 or 6 years, we are seeing assessments issued by URA that seem to depart from what was held a generally appreciated and understood position of the law, regardless of how the law stood. And the case in point, even before I go to Lualua, there was this matter of international transport. Whether international transport, was it Section 86, whether it had to be taxed generally or specifically. Then there was also the issue on deferred interest. I think for the longest time, until much more recently, it was a generally settled position within URA that those were not taxable positions, regardless of how you looked at the law. But I mean, the last 6 years, we've seen those seemingly controversial or gray areas or borderline position now elicit assessments from URA. This would also take us back to what Bruno is asking, the issue of withholding tax on disposal of assets. I know that provision is fairly new, but I think it was introduced in 2021, that if a resident person is purchasing a business asset from another resident person, you must pay 6% withholding tax. And a question that arose in the very first assessment that URA issued against Lualua was whether that transaction attracted withholding tax or not. And this is also the that Lualua matter went to High Court. Justice Ochaya gave his opinion. And then also recently, Justice Mobiru gave his opinion. Personally, I am much more persuaded by the decision of Justice Ochaya, because Justice Ochaya's position is in context. When a bank lends money to a borrower, what the bank recognizes as its income is the interest it earns off that debt. If the debt goes bad, what the bank will do, it will write it off, and it will even take a tax deduction in accordance with the BOU specific provision rules. Now, when it evokes the recovery measures and it sells the asset, it is going to reinstate that income as a reinstatement of the principal debt that was written off, and then interest. So in effect, if you want to apply 6% withholding tax on disposal of assets, that means you're taxing the bank on interest. Because when you look at Section 59 and Section 60, there's something called compensation should take the character of what the initial income was, or even when you recoup an expenditure, you still have to give it the original character it had. Of course, last week, the decision by Justice Mubiru was a subject of contentious debate on the tax practitioners group. And there's a point that Bruno made, which rang a bell in my head. Because what Bruno was saying is that you can distinguish the decision of Justice Mubiru. In the Lualua case, it's the bank which disposed. But in the decision of Justice Mubiru, it is the private parties which disposed. Of course, that is a very plausible argument for one to look at and rationalize Justice Mubiru's decision. But when you take a step back and ask yourself, is it possible for a private treaty sale to go on without the consent of the bank? Because there's going to be a security which is encumbered. And unless if the bank agrees that there's a sale, it can't take place. In fact, even when you make the sale, the proceeds are going to be deposited on an account of the bank, and the bank will apply that towards its debt recovery. So I think, regardless of the seemingly conflicting positions of the law, we as tax practitioners and URA and Ministry of Finance, we are duty-bound to the extent possible not to create controversies out of issues that ordinarily should not create controversies. If there was that understanding amongst ourselves, I would not even see a situation where we would keep pushing, demanding the 6% withholding tax. Just like how you've seen, I think the last 3 years, the VAT Act was amended. The first time, I think they tried to amend it, Parliament shut it down. That if there's a sale by an auctioneer, then VAT applies on that. But this is it's a financial transaction. If a bank is recovering its bad debts and it is selling a transaction, it falls within the realm of that. So the law was amended, and of course, when you looked at it, when we do debt recovery for banks, we never sign off those agreements in our names as auctioneers. You're still going to have the bank's name with the party who has bought it off. So likewise, even in this case of the recent Justice Mobiru position, it's very easy to cure if we cannot come to an agreement ourselves. That even where you have a private sale, but behind the scenes you agree that this is a private sale, but the parties to the agreement are going to be the banks. And then you avoid falling into that argument and contention of that.
Thank you so much, Mr. Dennis. And over to you, Tony, posing the same question. How should we go about these two decisions, in your view?
Yes, I have unlike my colleague Dennis, I hold a contrary view. And I find Justice Mubiru's decision more easy to reconcile with. About the distinction of whether we can distinguish the Lualua decision with that of Mwanga decision, I think it's the same. In Lualua, Equity Bank was selling to recover. But you see, in those transactions, the way mortgage deeds are designed, the bank is selling on behalf of the person who has defaulted. The moment you default, it stands in your shoes. So essentially, it's you also who is selling. Then if you look at this one of Paul Mwanga, what happens is that the moment he received money, the assignment of proceeds went directly to settle the loan. So essentially, in Lualua, the agent was selling on behalf of the principal, the taxpayer. But in Paul Mwanga, it's the principal was the one selling and remitted the money. So I think they are the same unless we are splitting hairs. But if we go to the real basics on why I agree with Justice Mubiri is that what you have to ask yourself is withholding tax final? And to me, that's where I pause. There are circumstances where withholding tax is final, payee. There are those circumstances. But in this scenario, the way I look at it, we would essentially defeat the purpose of withholding tax if we conflate, if we begin joining and looking through at the tail end. It's like a taxpayer saying, I will not file a return because I've not started any business, I've not made any money. The issue is you just file a nil one. So when it also comes to that door of withholding tax, fine, you're the bank, it's interest, it's not supposed to be taxable, just pay the tax. It's not final. At the end of the day, you reconcile, and if there is an excess, it will be given back to you. I don't see this effort of trying to prevent to even pay something that is not, because if, in my view, the simplistic view is that if it was not supposed to be paid, the section that says that withholding tax will be final in these circumstances, maybe they would have expressly stated so. But the Lualua decision joins sections of how interest is non-taxable, and therefore, since it's not, therefore you can't tax. And that same argument has been used in several decisions to be relied on. That's why you have circumstances of whereby now essentially there's no withholding tax. If at the end of the day, you look at cases like Tunga, they say, why are you giving? You can't even charge because at the end of the day, it's not. My view is that as far as the transaction is concerned, the elements are fulfilled. What is being sold, if it qualifies as then it should be paid. Now, what happens for you to argue that, but you say at the tail end the bank is exempt, then that's where I got lost with the Lualua decision. But just Mubiru clarified that. Then secondly, normally in all transactions, what the bank is recovering is not fully interest. Upon the sale, we all know that the proceeds of the sale will comprise of the interest, which we are holding high to say, look at it and not exempt, but also the principal will be recovered. There are costs of the auction, there are other fees. Why is it that we are throwing away the entire baby with the sink? Why don't we, worst case scenario, split? So for that, my view, I was like, it can't be that because part of the proceeds of the sale are used for the bank to pay interest, therefore all of it. So there, the Lualua decision, I was disagreeing with it in that length. Then also interpretation of tax. We all agree that tax is complex, but there is this analogy we normally use, is that when you find a provision that says A and you find another one that says B, the reasoning is there is ambiguity in favor of the taxpayer. Now that is the approach in Lualua. The judge acknowledged that one provision says withhold, however, this interest is not subject to tax, therefore there is a conflict. Therefore, but the harmonious interpretation of statutes taken by Justice Mubiri, in my view, is favorable. Otherwise, we'll be amending a section every day. Because as you see, maybe section, as an example, section 4(1) of the income tax will tell you, maybe subject to the act, everyone will pay, who has chargeable income will pay tax. But there are exemptions. You have to read everything as a whole, and you give it the purpose within which it was intended. So with that, my view, when I looked at both decisions, I felt like it was easier to defend the decision of Justice Mubiru, because withholding tax, at the end of the day, what is it? Is it final? Then why can't you interpret them harmoniously? Then are all the proceeds recovered, or are all proceeds comprised of interest only? That is not usually the case. So that is essentially where the reason why I would concur or agree more with Justice Mubiru. But still, the tribunal or other, now we have two decisions as to how we interpret them. I guess we'll pick one that is favorable to each party, and we try to convince. And it's not unusual in tax. You have cases that say, even from the same tribunal, there are cases that will tell you A and B. High Court, they are there. Court of Appeal, they are there. Even the Supreme Court has the decision. So it's the role of a lawyer is to marvel through, and we see how to apply. Thank you.
Thank you so much, Tony, for that analysis. I'm afraid our time is fast spent, but Mr. Okuja, to close out the discussion on the two decisions, do you think the discord is one that can be reconciled through judicial interpretations, or it is a situation that requires a legislative action?
Thank you, Bruno. I'm also going to add my voice. I totally did not agree with the Lualua decision because I believe it was misconceived. When you read that decision, the reasoning that the judge adopted was based on the sale proceeds. The whole decision is about the sale proceeds. The provision on withholding tax is on the purchaser. Those are completely different things. The obligation to withhold is on the person who is purchasing. The Lualua decision is based on the proceeds from the purchase, or rather from the sale. And that is where the judge got it wrong, in my view. So that whole decision is out of context, as far as I'm concerned. And therefore, I would agree with the decision of the Tax Appeals Tribunal, which was complemented by the decision of Mubiru, to the effect that, number one, there is no conflict in the provisions in the law. To the best of my knowledge, there is no conflicting provision under the Income Tax Act, for the simple reason that the design and structure of the Income Tax Act is based on the schedular income tax system, which relies on mutually exclusive categories of income, but under the central scheme of chargeable income. There cannot be any conflict in provisions. It's about understanding which category of income you're looking at and what rules apply to that particular category of income. If you take that approach, mindful that our income tax law is based on the schedular income tax system, you can never come across a conflict in any of the provisions under the Income Tax Act. Secondly, the confusion around foreclosures, whether in terms of withholding tax or even in terms of VAT, stems from the misconception that it is the banks that are selling, rather that own the property that is being sold. Under the Mortgage Act, there is nowhere that ownership is transferred to the bank at foreclosure. The bank is merely acting as an agent of the defaulting debtor or mortgager in this case. And when that happens, the sale by the bank is done on behalf of the defaulting mortgager. And therefore, to make the argument that the bank is recovering interest and principal is completely, I don't know what word to use to describe it. Okay? So, Lua, actually, when Benon told me we're going to look at Lua, it's one of those decisions I read and I did not save. I just discarded it. I asked him to send me a copy because it just didn't make sense to me regarding withholding tax, because the whole decision is on accounting for the proceeds from foreclosure, which is not the tax base for withholding tax on the sale of an asset or purchase of an asset in this particular case. So the point that the banking association or the bankers make is a genuine cause. And if they want an exclusion in the law to specifically exclude the proceeds from foreclosures to be subject to withholding tax, then they need to make that case before Parliament, such that the law is amended to exclude proceeds from foreclosures. But the law as it is, it imposes the tax base on the purchase. And like I said previously, as long as there is a business activity, as long as a business asset exists, then the obligation to withhold arises, irrespective of what the proceeds are going to be used for. Because Lua was arguing about what the proceeds are going to be used for, to offset principal and interest. Where is that in the law? So as far as I'm concerned, Justice Mubiru did justice in one page. Lua is 56 pages. I don't know what the judge was arguing over. But in my view, it was a completely misconceived decision. And Justice Mubiru's position is what I would side with.
Thank you so much, Mr. Okuja. Apologies for cutting you short, but we need to wind up the discussion. We have a few questions from colleagues appearing online. I don't know if we have a few questions here, but I hope that we can summarize responses to all the questions within 2 minutes, and at most 3. But Mr. Dennis, there is one for you here from Samuel Kahima. What happens in a direct disposal where the shareholders are non-residents, and what source rule do you apply? This is in respect of indirect share transfers. Mr. Dennis, in a minute.
Thanks, Sam, for that question. There's section 78G. I think there's also another section that pertains to movable properties. And then there's also another controversial one, I think section 78S, which when you look at tallow oil matter, I think the tribunal alluded to it. But of course, when you discuss it with practitioners, the positions are quite different, because under 78, was it S, it's any activity attributable to Uganda. And the argument some people raise is that even if I'm a non-resident, but I go and register a share transfer from that's an activity, it's a controversial position to take. But section 78G, if when you look at, if what I'm disposing of is principally movable property, then even if I'm a non-resident person, you have a right to tax. And of course, as some could be aware, the definition of movable property was amended in 2015. And in amending the definition of movable property, they included intangible assets. And I think that was in response to Zane, because I think URA was trying to go after that, using that provision. And of course, when you describe movable property to include intangible assets, you could easily bring its client base, customer base as an asset within the realm of movable property for you to argue that that actually is income source from Uganda. Thanks.
Thank you so much, Mr. Dennis. And then, Mr. Okuja, there is one for you here. If the administrator of the estate transfers land to a company where the beneficiaries are directors, is there a capital gains implication?
An administrator transfers land
to a company where the beneficiaries are directors.
The cost base of the asset would be rolled over, so there would be no capital gains implication at that point in time.
Thank you so much for that response. The question was from Mr. Godfrey Kena. Do we have any questions in a minute or 30 seconds?
Mine is a comment in relation to the submission by my brother Joseph on. So mine is a comment on what my brother Joseph commented on in respect of the disapplication of the treaty. There's a term you use actually, where you say by introducing deeming provisions, one could argue, deeming provisions on disposals, one could argue that you are interfering with the scheme of the treaty insofar as it has reserved to the resident state the right to tax capital gains, which do not fall elsewhere. Basically, the Article 14.4 type capital gains. Now, yes, thanks. So now, if you go back to Article 1, where it all starts, there's something which talks about persons covered. It says that this convention shall apply to persons who are resident of one or both of the contracting states. Now, because the deeming mechanism falls on the company, which is resident here, there is scope for argument that you're not violating the treaty because the treaty protects the shareholder who is resident in a foreign state, but as against Ugandan tax law, the treaty does not protect the company which is resident here. It could be here or there, but there is scope for that kind of argument. Maybe just one extra comment before you come in relation to, again, deeming under 74, again, in relation to what my brother Kakembo discussed. There's always been this question of whether by introducing the deeming provisions, you're introducing double taxation, whereby you could have taxation at corporate level in terms of 78H and 74.2, and then also create taxation at shareholder level within the scope of the rest of the provisions of Section 78 sourcing rules. We've had that discussion with the URA. As a matter of practice, they seem to follow one route versus the other, but within the statutory scheme itself, there's no real support for the approach that they have taken. So I think that's one area where some kind of amendment is needed. Thank you very much.
Thank you so much, Mr. Knobera. Mr. Okuja, if you could respond in a few seconds, and then we wind up the discussion.
Thank you. To respond to your question, one, there are two deeming provisions. The first deeming provision is the one under Section 78H, which now deems that the proceeds from a share sale that occurs offshore indirectly is deemed to be income sourced in Uganda. Now, that is the deeming provision that is expanding or taking away the right of the foreign country to tax proceeds from the sale of shares. And that is where the treaty override, in my view, occurs. Section 74.2 is imposing a tax, and Uganda is a sovereign state. It is free to impose tax on anybody, anyhow, and anywhere, the way it deems fit. So that provision, like I said, would apply in cases where the offshore transaction occurs with a company that has no, rather with a country that has no double taxation agreement with Uganda. But where there's a double taxation agreement, then 78H creates a treaty override by taking away the right which is exclusively granted to the country where the disposer of the share is located. So that's the distinction that has to be made. 74.2 can apply to anybody as long as there is no DTA. But 78H now deems a transaction, rather the income, to be sourced in Uganda, and that is where the treaty override, in my view, occurs. Yeah.
Thank you so much, Mr. Okuja. And with that, we come to the close of the panel discussion on recent trends in capital gains taxation in Uganda. Once again, I would like to thank our distinguished panelists for the very insightful contributions. Mr. Joseph Okuja, tax consultant and team lead at Libra Advocates and Consultants, and then Mr. Tony Karungi, who is the acting manager appeals litigation at Uganda Revenue Authority, and then last but not least, Mr. Dennis Kakembo, who is the managing partner at Crystal Advocates. Thank you so much for your insightful contributions. We have one last activity. We have a presentation on recent amendments, and that will be done by the team from ABMAC, led by Mr. Festus Aknobera. I don't know if you would like us to take off a break of about 2 minutes, and then we roll into that presentation. If you wish, we can also just delve into it right away. I think the silent opinion is that a break of 2 minutes is preferred. So let's break off for 2 minutes, and then we will be back for that last presentation for the day. Thank you. Good afternoon once again. May I request that we take our seats so that we can have the last segment for the day. Yes, thank you so much. Our last segment today focuses on tax amendments that were tabled and subsequently passed by Parliament. They have also been assented to by the President of the Republic of Uganda, so definitely we are speaking about laws that are in force. And to lead us throughout this segment is a team from ABMAC Associates, Advocates, and Legal Consultants, led by Mr. Festus Aknobera, seated just next to me. Mr. Festus is an advocate of the High Court of Uganda. He's an attorney and counselor at law, New York. He's a Hausa Global Scholar and a holder of an LLM in International Tax Law from the New York University School of Law. He also holds a Bachelor of Laws degree from Makerere University, and he has the record highest CGPA from Makerere University. He's ranked in Chambers Global from 2018 to date as a leading tax practitioner in Uganda. Mr. Festus has practiced tax for over 15 years. Mr. Festus, you're welcome, and we look forward to your contributions. The other presenter, also from ABMAC Associates, is Jemima Mushabe. Jemima is an advocate of the High Court and all subordinate courts in Uganda. She holds a Bachelor of Laws degree from Makerere University, a postgraduate diploma in legal practice from the Law Development Center, and a postgraduate diploma in tax and revenue administration from the East African School of Taxation. Jemima, you are most welcome, and we look forward to your insightful contributions. And at this point, I want to hand over to the eminent team to take us through this segment. Thank you.
Thank you very much, Bruno. And thank you again for the introduction. So we are honored to be here today. We're Team ABMAC, as Bruno has introduced us, and we'll be taking you through the key tax amendments which have taken effect 1st July 2025, and which will remain in force for the financial year and possibly for additional financial years if they don't get repealed. Now, there are several amendments that were introduced, but what we're going to do is focus on what would be the key amendments. So we are not going to speak to each and everything, but those that we consider material in terms of the potential that they have to impact the economy or to impact taxpayers significantly. So this presentation will be done by myself and Jemima. I will cover the income tax amendment aspects, VAT amendment aspects, and the tax procedure code amendment elements. And then Jemima will cover excise duty, stamp duty, and external trade aspects of that presentation. So to get into the income tax amendments, and maybe before I get into the specifics, I would say that my overall observation of what has transpired in those amendments is that the government has stayed away from introducing new taxes or increasing taxes. So you'll see that the trend is more in the direction of either maintaining existing law or clarifying existing law or providing some kind of relief to taxpayers. That is the general trajectory that we have seen in the amendments that happened this year. We've also seen there's a move towards simplification of administration to achieve efficiency through digitization of tax administration, as we'll see elements on strengthening IFRIS and elements on introducing an IFRIS equivalent kind of system for persons in the gaming and casino business, which is all towards the direction of simplifying administration reducing cost of administration, and also having real-time access to information on the URA side. So with those few observations, I will now tackle some of the key points. I believe we all know or have heard about the Bujagali hydropower. In the amendment, there's an exemption, an income tax exemption this year, which, by the way, has been hovering around for some years. But this year, they've clarified that the exemption will run up to June 30th, 2026. In the past, there was some introduction which suggested that it would move up to 2032 or 33, but that was clawed back to run on a year-by-year basis, and the current position is it will run up to 30th June 2026. For those who may be familiar with the power sector, the tariff question is always a very big question. The tariff of the power that you use. And this exemption is partly an issue of how do you bring down the tariff. Somebody is generating power under a power generation license with the government, has incurred certain costs to be able to put up the project, and needs to be able to recoup their investment according to the business plan they produced, but needs to do so in a manner that allows also the government to deliver power at a cost which is affordable by the taxpayer, by industry, by general consumers. So a lot of back-end negotiations have been happening over time, including potential refinancing of this project to bring the tariff down. And I think the tax exemption is in the spirit of saying, let's have this exemption run as a way to maintain a certain minimum tariff in order to keep power affordable by the public. So again, in the grand scheme of things, this is a public interest tax initiative, which is to support a project with a view to lowering tariff and making it easy for consumers to access power and making it affordable for businesses to use power. Now, whether that end has in fact been achieved is a question for another day, and maybe Brian from the URA will give us additional context on that. Now, there is an additional amendment. Again, this is in the context of making the business environment friendlier to taxpayers. So this particular exemption for startup businesses, effective 1st July 2025, again is for the small players. For the small players, which is to say, if you have freshly registered or recently registered a business, your capital outlay or capital investment is not going to exceed 500 million Uganda shillings. You are a citizen, and remember the definition of citizen under the Income Tax Act means a citizen of the ESE. So you can also be Kenyan, Tanzanian, Rwandan, and you still be a citizen in the context of this legislation. So you've registered a business, you're investing not more than 500 million Uganda shillings, you are a citizen, okay, and you're compliant, although that's a subjective test, but for now, let's assume that you are compliant. You are granted a 3-year tax exemption, okay, from income tax, effective 1st July, if your business is established after 1st July. So this is really for new entrants, new startup people. And if you look at the capital outlay, it's really targeting small players. I don't think in your categorization in the URA that's medium. Probably that's really small. So this is supposed to help the Muntu Wawansi, as they call it on the street. Start up your business, organize yourself. We're going to give you a platform to comply, but we're going to give you an exemption for 3 years. Now, this is a very good initiative, which is to be commended, obviously. The question you have to ask yourself is whether within that 3-year period, like any other startup business, you will have generated sufficient income to offset your investment cost and achieve positive chargeable income, which then effectively you're getting an exemption for. So at least at the top level, it looks fantastic, but in practical terms, it looks like by the time you actually begin to get chargeable income is the time when the tax is kicking in. So fresh look could be had on this, maybe to provide a slightly longer period. Obviously, business is multifaceted. There are sectors where you can move faster and begin to achieve positive chargeable income, but there are some where you need at least 2 or 3 years to gain stability and begin to even start to get some revenues. But still, good initiative, and it is something to be considered for potentially for extension. There was a talk about rollover relief earlier, and I think you have now fair clarity on what rollover relief is. Rollover relief is, as my colleagues earlier explained, a mechanism to exempt you from capital gains tax, where capital gains tax would otherwise apply if there was a disposal. This typically will happen if there's a transfer of an asset. Now, the law provides a mechanism for you to get that relief, as my colleagues earlier explained. This is in section 76, and there are 3 scenarios in very broad terms. The first scenario is where you're contributing assets to establish a company, okay? The second scenario is where a company is distributing assets in liquidation. And the third scenario is where assets are transferred within a corporate solution in the context of a reorganization. And this is the amendment that has happened this year. So a reorganization is defined under section 76(4) in various ways. But if you try to move away from the legislation and just think of it in layman's terms, you can be conducting business, okay? You want to achieve efficiency in the manner in which you conduct that business. And in order to do that, you may want to do some restructuring, okay? So restructuring of a business can take different forms. It can be a corporate division where you're splitting up assets and allocating them to different centers of excellence. It can be a consolidation where you're moving different assets from different entities and consolidating them, again, maybe to achieve certain efficiencies. It can be where you're trying to minimize cost centers and create concentration in a specific level. It can also be where you're trying to probably create more concentration in an entity, and therefore you have to move assets from one direction and repackage them in another direction. But the common theme in all of those scenarios and several others, which I have not mentioned, is that you're trying to achieve efficiency in order for you to effectively conduct business at low cost. Everybody who has done business knows that in a capitalist setting, profit maximization is the ultimate objective. Therefore, everything that somebody will be doing in moving assets around within the corporate solution or within the group that has different corporate entities is to have efficiency, reduce cost, increase profit. Now, under previous law, which has just been amended, in a corporate reorganization, a transfer of an asset within the corporate solution as part of a reorganization was recognized only in the context of a transfer by a company, okay, to another company. That provision did not envisage an individual, natural person like you and me, transferring an asset within the context of that reorganization. That was paragraph A as it then was. You can see what it said before, a transaction in which a company transfers its assets. So it envisaged only where the transferor is a company. But under the new legislation, it has said a transaction in which a person transfers their assets. Now, if you go to the definition of a person under the Income Tax Act, you will see that it caters for more than just a company. It covers companies, obviously, trusts, partnerships, individuals, which can be you and I, natural persons. So this has left scope for a transfer by individuals also to fall within the rubric of 76(4)A, which increases flexibility or breadth of what can be considered a reorganization, in a sense in which when that happens or asset transfers happen in that context, rollover relief can be granted, i.e. that whereas there would be a disposal in the traditional sense, the law will switch off that disposal, treat it as if it's not a disposal, the effect being that the tax attributes of the asset transferred, which is the cost base of that asset, will roll over into the hands of the next holder. And by doing so, you're preserving the inbuilt gain or inbuilt loss of that asset in the hands of the transferee, and therefore preserving the ability to tax a disposal of that asset in the hands of the transferee at a future date. So you're saying that, in essence, we will not tax you now because effectively the economic control of the asset or economic or beneficial ownership of the asset has remained, because the controller of the transferee is still the person transferring the asset. So by controlling the transferee, this person has an economic interest in the underlying assets of the entity. So we won't tax now because it's simply a restructuring or reorganization, but we will tax at a future date should a disposal occur by the transferee, because we have preserved the tax attributes, crucially, the cost base of that asset in the hands of the transferee. So what really has happened here is to expand the scope of who can transfer an asset, and we still recognize a reorganization with a view to creating more opportunities for rollover relief than would exist under the old law. There is also a clarificatory amendment here in relation to digital services. And what it says is that transfers to associates, okay, transfers to associates or transactions between associates in digital services are not going to benefit from the 5% tax rate that is prescribed in Section 86. What does that mean? Let's look at it first in the ordinary context, and then second in the context in which the amendment is being proposed. So we all know that in the global era of e-commerce, you can access services here even when the provider of that service is not here, is not within jurisdiction. An example is, I think we're all subscribers to Netflix, right? Those who like movies and series and that kind of stuff. So we subscribe to Netflix, we subscribe for certain Google products, for example, Gmail, the cloud-based system and all that. There are some subscriptions you're paying. Those are digital services you're paying for. But the person you're paying is not necessarily located here. So that law is saying that if somebody is providing digital services, the existing law, 5% applies. But this amendment is clarifying that if the transfer is between associates, then the 5% doesn't apply, which means we default to the existing law. So what is the existing law? The existing law is if there are services provided by a non-resident person, okay, and a contract which is called, there's a contract, what's the name of that contract? A Ugandan source services contract in the context of the former 85, which I think is 84 now. Under that traditional setup, if a non-resident is providing services to a person in Uganda under Ugandan source services contract, which is a defined term, the rate of tax would be 15%. Okay? Now, what this amendment is saying is, if you're providing digital services to an associate, okay, the rate of tax is not going to be 5%. It's not telling you it's 15%. It is simply telling you it's not going to be 5%. So if it's not 5%, then what is it? By interpretation, you can come to the 15%. Now, who is an associate? An associate is variously defined under the law, but it would mean generally, if I can give some very concrete examples, a shareholder in a company where that shareholder owns at least 50%. Okay? So the shareholder and the company would be associates. So think of parent-subsidiary relationships in the context of multinational corporations. If you have a subsidiary here, for example, Google Uganda Limited, for just ease of clarification or illustration. If you have Google Uganda Limited, which is owned by Google Inc., let's say a US entity or a Scottish entity, Irish entity, they like Ireland. So probably it's in Ireland. So if Google Inc. in Ireland is a parent, i.e. a controlling entity owning more than 50% of Google Uganda, and there are certain services, okay, that Google Uganda Limited is utilizing from the mother entity, we're not applying the 5% regime, we're applying the 15% regime. That's an example in that context. Another scenario of associates could be husband and wife, but not likely that those are the people being targeted. It can be partner to partnership relationship. You're a partner in a partnership, so you're an associate to that partnership, which is a person in the in the income tax context, or a partner and partner where both partners are joint partners in a partnership. Trustee and a trust, beneficiary and a trust. There are several scenarios where you can be considered an associate. Now, obviously, in the context of Uganda, as my colleague Kakembo earlier mentioned, trusts are not very common. But for those who have understood the magical power of a trust, it is quite a very useful instrument in tax planning. And probably this is not something that URA would be very happy about me talking about. But not a very well-developed area here, but quite a well-developed area in international business. And if you understand the mechanics of how it works, it's a very interesting construct to do business. So I'll move away from that. There is a consequential, what I will call a consequential amendment to define the IAEA. I think previously they had called it the Atomic Energy Agency. Its name changed, it's now IAEA, but there's nothing which has changed. It's already an existing entity, but it's just a classification. It's a change of its name to say it's not Atomic Energy Agency, but International Atomic Energy Agency. This is to do with nuclear issues. If you've been following Iran and other places, that entity helps to monitor how states are doing, how states are complying with their obligations under certain nuclear non-proliferation treaties. So those are the key amendments. We have not gone into each and every amendment, but we think those give context to where the economy is trying to go. And the idea is that government, again, is trying to provide either clarification or some kind of relief, actual or perceived. And as I have noted, at least the gesture is good, but the mechanics in terms of how it's applied, maybe there could be some improvement. And we applaud government for the gesture. In terms of the VAT Act, there are some targeted amendments, but overall framework, in my assessment, is the government is also looking at supporting clean energy. If you've been following world events, there is a lot of noise around fossil fuels and energy efficiency. The more energy you use, the more likely you spoil or damage the world. Therefore, you want to be as efficient as possible in using energy, taking a conservation approach. You want to use renewable energy as much as possible, or you want to use efficient energy whereby you reduce down the rate at which you're depleting depletable reserves such as forests. So in this context, you can see that solar is a very good alternative, because the advantage of solar is that it comes from the sun, you just need to tap it, you don't need to damage anything, okay? So you'll see that there's an exemption for solar lanterns in the Act, and the idea there is to, again, promote solar as an alternative to the traditional sources of energy, some of which could be damaging to the environment. Now, in Schedule 3, they've introduced something which is an exemption for the supply of biomass pellets. Biomass pellets, if you may have followed, those are pellets which could be derived from residues. Okay, so for example, somebody who is farming, you can have a lot of trash, maybe maize stalk or sugarcane stalk. I like a lot about sugarcane, because that's a business that happens in my home area. So sugarcane stalk or maize stalk or any other stalk that you can use to convert into pellets. Biomass. Biomass is naturally occurring or man-made vegetation, okay, which then you can convert into pellets, which then you can use as a source of energy. So this is really like a substitute for charcoal, for example. The person who is doing charcoal is cutting a tree, burning charcoal, okay, that person is causing damage to the environment. But the person who is reusing, for example, agricultural stuff, agricultural feedstock or stock, is using materials which would otherwise have been going to waste and converting them into a source of energy. And it creates an alternative for somebody who is cutting charcoal and damaging the environment through deforestation. So this exemption is intended to promote the use of biomass as a source of energy. Now, if you pay a little bit of attention, you'll see that when you have an exemption for VAT purposes, what actually happens? That's a question we need to interrogate, okay? When you have an exemption as a business, when the product you supply as a business is exempted, okay, it means you don't charge VAT to the end user, okay, to the customer. That's a positive thing to the customer because you don't have to increase the price at which the product is being sold. So it's good news for the consumer. But there's a bit of a catch. When you deal in exempt products, which is you supply exempt products, you have a problem with input VAT. Because on the input VAT side, you will not get credit for input VAT where the end product you're supplying is exempt. That means that the input VAT becomes a cost to you. So when analyzed, the best method to achieve an efficient outcome for both consumer and the business is the zero rating mechanism. Because when you do the zero rating mechanism, what is happening is the transaction is still considered taxable. Okay? So taxable has two strands. Either it's taxable as standard rated, which is the classical 18% that we all know about, or taxable as zero rated. Now, zero rated and exempt will have the same effect on the customer side, but will have different effects on the business side. If it is zero rated on the business side, then input credit is recoverable, which means you pick some money from the URA for the input VAT you were charged when purchasing inputs for the business. On the other hand, if it is exempted, if the product is exempted, then you don't get that input credit. So in order for us to truly achieve the objectives that we're trying to chase here, I think we need to go the zero-rated route rather than the exemption route, so that the benefit accrues not just to the final consumer, but also to the business that is undertaking operations. There's a repeal on exemption for the supply of billets. I am not entirely sure what that seeks to achieve. Billets is still billets. One might say we're trying to reduce the cost. No, this is a repeal of an exemption, which means charge VAT, okay? But the billets typically are used by manufacturers, right? So even if you charge the manufacturer VAT, it's going to charge on the final product. So he will pass over the cost through the chain of VAT trail. So it's not a big problem for the manufacturer. But one might say that because on the input side of the manufacturer, there's already a built-in cost which is going to be passed over, the person who's going to be hurt probably is the final consumer. So government could be chasing some objectives, and maybe Brian will explain to us why this particular amendment is there. Maybe they want money, and the need for money is also policy. Policy isn't entirely about supporting certain sectors. So maybe the policy is money.
Maybe if I may, from my discussion with some manufacturers,
yeah,
they actually lobbied for the repeal of the exemption,
okay,
because the billets are sourced through imports, one, and secondly, we have local manufacturers. So during the existence of the exemption, the local manufacturers were not able to claim input. And yet those that were importing didn't have the input cost. So the repeal is to enable the local manufacturers to claim the input cost.
Fantastic. Thank you very much for that. Do we automatically get back? Okay, I suppose I believe this is the back button. Yeah, okay. So that's a very good clarification, gives us context, but as Brian also mentioned, maybe money is also an element, but I'm sure moderator will give him a chance to make some clarifications. Zero rating on the supply of aircraft. I suppose this is intended to support Uganda Airlines, right? We're trying to promote a national carrier, so it's therefore crucial that at this time we focus on zero rating. And again, remind me, the supply of transportation services is VAT exempt. Local transportation. International, on the other hand, is zero rated. Okay. So this is really to support, I suppose, Uganda Airlines. But context matters, because what it's saying is zero rate the supply of aircrafts. So if Uganda Airlines wants to supply, not import, of aircraft. Okay, I need to look at the text again, but typically a supply and an import are distinguishable under Section 4 of the VAT Act. So supply would presuppose this is purely domestic. One would then understand that this is a local person trying to sell aircraft. I don't know if that makes sense in the context of our economy, but assuming it does, then the idea is to make it cheaper. Yeah, absolutely. Now, the additional change is again a consequential amendment where they are including certain UN-related agencies within the list of public international organizations. These are exempt from VAT and under the VAT Act. This is really a clarificatory amendment because it was already the position, but it's just to emphasize that UN and certain specialized agencies which have been added are all part of that exemption program. So the next item is the Excise Duty Amendment Act, but I'm going to skip on that because my colleague will deal with it. I am going to go to, I'll skip stamp duty as well, and I'll skip that as well. I'll go to the Tax Procedures Code Act to highlight some of the changes that have been introduced this year. So the big one is the use of NINs as TINs, but that law will come into force when a statutory instrument is passed by the minister appointing the coming into force of that particular Section 2 of that Amendment Act. The idea here is, instead of going for a TIN, every majority Ugandans are registered. Just plug on the NINs and all of a sudden everybody has a tax identification number. And in the context of businesses, if you're registered with URSB, Uganda Registration Services Bureau, your business registration number is automatically to be used as a tax identification number. I perceive the benefit of that to be simplification. We don't have to hunt down every Ugandan and tell them to register because they can automatically be registered. So it helps the URA and also helps the individual in that you don't have to go through the paperwork, because all you need to do is to plug into the NERA system and you get all the information, or plug into the URSB system and get all the information and automatically assign new or reprogram the NINs to function as TINs. How it's going to be done, I think, is probably a very complex one, and that's why probably the minister is still working behind the scenes with the team to understand how that will play out. Hence the decision by government to pause and activate it when they are ready and be able to activate it by statutory instrument. But again, government will provide more context on this. Then there is this clause on waiver of interest and penalty. This has been also a permanent fixture since COVID. And it says that if you pay your principal tax by a certain date, then interest and penalties are waived. Interest and penalties typically under the law, as you know, arise when you late pay your tax. When you late pay your tax, is an interest, okay, time value of money, which is embedded in the statute. Penalties, if the taxman thinks that you have violated law, tax law, there are certain penalties which are imposed by law. Those are all waived if you pay the principal tax by a certain date. And in this context, they're saying for this year, any tax, okay? Any tax which was outstanding as at June 30th, 2024, if it is paid by June 30th, 2026, which is the new year, any interest and penalties on that will be waived. Okay? And there's a clarification still within the amendment saying that that waiver applies also to interest that accrues on the principal tax from 1st July 2024. So again, if you follow the trends, this is a relief which has been provided since COVID on a year-by-year basis. And the idea has been that people have suffered economic fallout because of COVID and the crippling effects. So government is trying to provide relief so that they don't have to suffer the impact of penalties and interest. So provide some relief to taxpayers, but also by creating a certain cut-off date by which you must pay, it's also encouraging compliance, that people can come and pay up their principal tax and come up to date. And by doing so, then the URA can also ramp up collections for the people who would otherwise have stayed away by creating some kind of ultimatum or sunset element by which date then they should have paid and then they can catch a benefit. Advising clients from different angles, I have seen that this is a very important clause. The few times it has appeared for the different tax years, taxpayers have tried to pay by the designated date. So it's actually a positive clause which is beneficial to both taxpayer in that it provides relief, and beneficial to government in that the taxpayer who would have stayed away will try to pay in order to have that clean record and move forward smoothly. So it's a positive on both strands. IFRS, there's now a standardization of the penal tax for failure to apply or implement IFRS. So if you sell goods, or if you supply services, and you don't issue an IFRS invoice, we're all familiar with IFRS, that electronic fiscal receipting and invoicing system, which the URA introduced, was it 3 years ago? About 3 years ago? 2 or 3 years ago. If you're not plugged onto that system, and you're not issuing invoices via that system, you're going to suffer a penalty, but that penalty has now been standardized. Previously, it was saying double the tax. Yeah, so double the tax or 300 currency points, whichever is greater. But that could have some inconsistencies in some scenarios. An example could be, what is 300 currency points? 6 million. If you deal with a small guy who has sold goods, let's say for 500,000 and has not issued an IFRS invoice, and you're billing him 6 million, there is an issue of proportionality. You know, under the law and under principles of equity, canons of fair taxation, proportionality is one of them. But even under the law generally, on penalties, the principles require that the penalty should be proportionate to the gravity of what has been done. And in quantum terms, if I'm dealing with a sale of 500,000 and you bill me 6 million, it will be out of proportion. So what they've now done is standardize and say double the tax due on the goods. So at least that can keep it within the realm of proportionality, because if it's high, it will be double that high amount. If it's low, it will be double that low amount. So it's a standardization, but intended to achieve proportionality, which ultimately is a fairness concept. As far as gaming is concerned, what this rule is saying is we're introducing, to make it simple, we're introducing an IFRS equivalent for the people in the gaming business. You must plug onto a system which is linked to URA, which IFRS is. So the casinos and gambling houses have their own system, but it's an IFRS equivalent, and they should actually also subscribe to that system, failing which they will have their own penalties to pay, which is quite a substantial number, 5,500 currency points, which is 110 million, but the casino guys can afford it, I think. They are generally reasonably large taxpayers. They are not the small guy that we are typically worried about. Then there's a clarificatory amendment on persons who have tax exemptions. So under the law, income tax law and other laws, but mainly on the income tax side and the VAT side, there are certain exemptions which are for certain sectors or for persons who fulfill certain investment thresholds and things like that, or persons who employ a certain number of Ugandans. So you go through a test of qualification. Are you in this sector? Are you investing as much money? Are you hiring Ugandans? Are you using raw materials, at least a certain proportion for Ugandans, from Uganda? That kind of eligibility criteria. What this law is clarifying is, if you fail to maintain the eligibility criteria, then the exemption given to you will collapse. I call this clarificatory because it was always understood that that's the position, but this clarification makes it clear for anyone who may have had any doubts about that. So thank you very much. In the interim, I'll pause it here to allow my colleague continue with stamp duty and other aspects. Yeah.
Good afternoon, everyone. So in the excise duty, one of the amendments that has been made is to provide for remission of excise duty, especially where the goods that on which duty has been paid have either been damaged, they are expired, or they are obsolete. So if a taxpayer paid excise duty, but the goods have been damaged, expired, or obsolete, it would be unfair for them to have paid that tax and then they are not benefiting from the goods. So the law has been amended to allow that taxpayer to apply for a remission of the tax, and that application has to be supported by certain documentation. So one, you must prove that actually excise duty was paid on those goods. Then you also must prove that the goods were delivered to you. So it could be in the form of documentation. It could be like an order for delivery. Then in the case of damaged goods, you need to prove the cause and extent of the damage, and that is by way of a report from a competent authority. And then, of course, the law provides that any other documentation that the minister may prescribe by regulation. So if you have proven that the goods are indeed either damaged, expired, or obsolete, and that duty was paid on those goods, then the commissioner can apply that duty to offset any other duty that is due from that taxpayer, or the taxpayer may opt and say that that duty be applied to reduce any other tax liability that they have in respect to any other taxes that they have to pay that are undisputed. So that amendment provides a relief to a taxpayer so that they do not lose out on both the goods and the duty, and they are able to apply that duty to offset any other taxes that they may have. Then there has also been a change in the duty rates for some of the goods where the duty rates have been increased. So looking at cigarettes, both imported and locally produced, there has been an increase in the duty rate. Then also for beer, where they are made from 75% local raw material content, they have removed the middle tier, which was beer from barley grown and malted in Uganda. So that is now encompassed under beer that is made from local raw materials. So previously the duty was 30% or 650 per liter, whichever is higher, and now it is 30% or 900 shillings per liter, whichever is higher. Then in respect to fruit and vegetable juice, the pulp content has also been increased. So in order for fruit and vegetable juice to be exempt from excise duty, that juice must contain at least 50% of pulp from fruits and vegetables that are locally grown within a partner state. So the move here is to encourage the use of locally grown fruits and vegetables, and really to boost the agro-processing industry within Uganda. Then there has also been a clarification on plastic products, and that is just to say that the plastic products that are subject to excise duty are those plastics that are under those SH codes, which is 3923-2100 and 3923-2900. So there's an exemption for plastics that are vacuum packaging packs for food, juice, tea, and those that are for use in sanitary pads. So they're just clarifying which plastics will actually be subject to excise duty. So moving on to stamp duty, there has been an amendment to remove the stamp duty on agreements or memorandum of agreements. As we all know, there was previously a notice from the URA where they were clarifying that all agreements and memorandums of agreement would be subject to stamp duty. That was at the rate of 15,000, and that created, it creates a bit of difficulty, especially for businesses where you are executing a large number of contracts, and so you then have to pay duty on all these contracts and agreements that you're entering into. So with the removal of stamp duty on agreements, it then makes it easier for you to do business and then engage and execute as many contracts as is needed for the purposes of your business. The other thing has been to remove stamp duty also on mortgages, mortgage deeds, and really that is to facilitate access of credit and also reduce the cost of acquiring credit, which would be a welcome move, especially in promoting investment and making sure that people can access credit and credit is affordable. Then moving on to the External Trade Amendment Act. What has been introduced is an infrastructure levy and an import declaration fee on the customs value of goods that are imported for home use. But maybe just to clarify, infrastructure levy is something that is already happening and was imposed under an ESC legal notice, but it did not have a domestic equivalent in Uganda. So what the law is now doing is domesticating that levy within Ugandan law and giving it the force of law in Uganda. So you have an infrastructure levy of 1.5% on goods imported for home use, but in addition to that, there will be an import declaration fee of 1%. And the Act also clarifies what home use is, and those are goods that are imported for free circulation within Uganda. So it doesn't include goods that have been that will be re-exported or goods in transit. And then the Act also exempts certain goods from that infrastructure levy and import declaration fee. And one of those exemptions are goods and products that are already exempted under the 5th schedule of the ESC Customs Management Act. Then there's also an exemption for plant and machinery described under chapters 84 and 85 of the Harmonized Description Code. And then also goods that are imported in respect to a special operating framework with the government of Uganda. So in addition, there is also an export levy, and that will be imposed on wheat bran, cotton cake, and maize bran, which are consigned out of Uganda. Thank you.
Thank you so much, Mr. Festus and Ms. Jemima. We also have a representative from the Uganda Revenue Authority, Mr. Brian Mugasa. Yes, Mr. Brian Mugasha, my apologies. He works with the Uganda Revenue Authority in the Business Policy and Rulings Division, and he has a few comments and remarks to make in regards to the amendments. Mr. Brian, you're welcome.
Oh, thank you. I just wanted to make a few additions to what the presenters have just presented. I wanted to talk about IFRIS. There are items that have been introduced through a public notice that some of you might not be aware of, but I think it would be prudent for you to know now, given that the audience that we are looking at is very vast and must be engaging in some of these activities. So the new sectors that IFRIS affects, we have the wholesale and retail of fuel. So anybody who is dealing in that should issue an IFRIS invoice. Mining and quarrying, manufacturing, this is regardless of whether you're registered for VAT or not. It is mandatory now for you to issue IFRIS invoices. Anyone dealing in electricity, gas, steam, and air conditioning supply. Then there's water supply, sewerage, waste management, and remediation activities. Anyone engaged in construction, transportation and storage, accommodation and food services, information technology and communication, real estate activities, professional, scientific and technical activities, arts, entertainment, and recreation. Given the audience that is listening to this, I think what would be most relevant to you would be professional services. So if you're offering professional services, like you all do, regardless of whether you're registered for VAT or not, it is now mandatory for you to issue an IFRIS invoice. Otherwise, you will suffer the penalties that my colleague Festus talked about earlier. Then for excise duty, you talked about the provision on plastics. Plastics has been very political and dynamic. I think this financial year it was prudent that we came up with a position that is clear. The initial wording of the law was very vast and captured every kind of plastic. So the fiscal policy for this final year is basically to target plastics from materials made for sacks and materials for conveying goods. So the HS codes that are provided for, that Jemima talked about, those HS codes are really looking at packaging material that is made from plastics. So that is for your information. The exception is for vacuum packaging, vacuum bags, packaging bags for food, juices, tea and coffee sacks, and bags for direct use in the manufacture of sanitary pads. What else had I? The exemption, the 3-year exemption for the small taxpayers. We are imploring everyone who is small and who is really newly registered to take advantage of this exemption. As Festus has said, some of you might not be able to benefit from recouping your profits within the 3 years, but it is given the sector that we are looking at, we expect and anticipate that you should be able to actually recoup your profit from them. The 500 million cap, this is on capital investment. Some people were wondering if this is a share capital. No, it's not on share capital, it's on actual capital investment. And capital investment, you're looking at capital goods that you would have invested in your business. So please feel free to enjoy the exemptions that the government has extended to you in such a sensitive period of our economy. Thank you very much.
Thank you so much, Brian. Do we have any questions regarding the recent amendments? I'm sure our presenters would be happy to take 1 or 2 questions. Yes, Winston.
So I don't know if the panelists would like to clarify if they think that the amendment in paragraph 1J about supply vis-a-vis imports, whether it was bad draftsmanship or it's just it was deliberate. Yeah, about the aircrafts. Was it a deliberate introduction, or it was a case of something that was missed?
I think it was deliberate. I don't think there are any amendments that were not deliberate. But I think there's a growth in the aircraft industry, and these are some of the proposals that have been made to encourage more investment in the aircraft sector. I don't know how many people can afford to purchase or sell aircrafts, but hopefully, given the growth that the economy is taking, maybe we will have more players who are transacting in aeroplanes in the Ugandan economy. Thank you.
Thank you. Mr. Festus or Jemima, do you have anything to add on Winston's question?
Yes, just to supplement on Brian. Now that I think about it, there are also these airports which are being done locally, some to the level of international, but still they are supposed to support domestic mobility as well. So in order for us to increase traffic on some of these airports where government has spent money, I think this kind of policy is appropriate, because it would then encourage people to acquire aircraft or to use aircraft services, and therefore encourage participants in business in that sector to acquire more aircraft to support domestic mobility.
Yes.
Mine is on the tax exemption of startups. Is it the provision just trying to bring more taxpayers into the fold? Because like you say, the 3 exemption, by the time startups break even, they're past the 3-year mark. So if you're exempting nothing, chances are high you won't have anything to exempt. And they just trying to make you register when you have no tax obligation. So that in future, you're now, whenever the exemptions, whenever the tax payable rises.
Brian, do you want to answer that, or do you want me to answer that? So, you see, with every tax amendment or tax legislative measure, there are 2 key players. One is the taxpayer, the other is the URA. So in policy, in tax policy, sometimes you use a carrot and stick approach, or sometimes you use bait. So it's supposed to be a win-win situation. We're encouraging you to register. By registering, you've taken a step towards formalization. Obviously, there are multiple benefits to being registered. Even to enjoy this exemption, you will need to have financial statements. How do you prove that you've invested 500 million? You may pile up some invoices here and there, but they will ask you, take all those to a CPA, a certified public accountant, do some financial statements. We want to see how the balance sheet looks like. So by trying to comply and get the exemption, you're formalizing your business. And I think the biggest problem in this country is the informal sector. So by encouraging these small players to incrementally register, get formalized, you're also helping them to be organized in the way they are running business. And when you're organized, it's very easy to access capital. It's very easy for you to transition from that very small 500 million business to a multi-billion business. So it's a positive for the taxpayer because it's giving them opportunity to regularize affairs, be more organized, and participate in the formal space, which comes with a number of benefits. Access to capital being really, for me, the biggest point. It's also good for URA because then, as you're participating in the formal space, they're able to have better statistics on who the economic participants are. The growth in GDP of the economy can be more realistically measured. The tax policy people can plan better, what kind of people are coming into the fold in the next 5, in the next 10 years. So ultimately, it's good for both the taxpayer and the URA, because after the 3 years, there will be a tax. There could be a lobby, as you know. Lobbies are big time in this town. So after 3 years, I suspect it's going to be extended, because I don't think that 3 years would be a reasonable time. Probably 5 would have been a better time. It still gives a win-win for both the taxpayer and the URA.
Yes, Vanessa, your hand is up.
Thank you. I just have a question to Brian's presentation about the need to issue invoices, specifically if we are looking at, say, professional services, which is what majority of us are doing here. So from my understanding, you have to be VAT registered to charge VAT. So practically, am I supposed to issue an IFRS invoice? How do I classify it? Do I say it's exempt? Do I say it's standard rated? Do I charge VAT? If technically it is, but I'm not registered for VAT.
Okay. The issue of IFRS invoices. One, it is a good way for formalization and collection of our revenue. We have noted that there are people who are required to be registered for VAT, but have been dodging to register for VAT simply for purposes of not issuing IFRS invoices. And now this notice, which is issued by the Commissioner General under the powers that he's granted under the IFRS law, is basically meant to get all those people who would be registered for VAT but are not, and they're using that as a reason not to issue IFRS invoices, to be able to issue IFRS invoices. The services that we are talking about here are mostly taxable supplies. But for any professional who is issuing or who is dealing in exempt supplies, like medical services, they will not issue an IFRS invoice. They can issue an e-receipt. Now, that e-receipt is also connected to our IFRS system, and that is information that would be reflected on our side, and that should not be a reason not to issue the IFRS invoice because you're dealing in exempt supplies. Hope that answers your question.
My question is on the taxable supplies.
Yeah.
Am I supposed to charge VAT on the taxable supplies if I'm not VAT registered?
If you're not VAT registered, but you are required to be VAT registered, then yes, you should charge VAT. Okay.
I'm not meeting the threshold. I'm not making 37.5 million in 3 months.
Okay, so if you do not meet the registration threshold and you're dealing in taxable supplies, you should not charge VAT on the supplies that you make because you are not a taxable person as defined under our law. However, you would still be required to issue the e-receipt without the VAT. Is that okay? Yeah.
Thank you so much. Tony, your hand was up. Did you have a clarification to make?
Thank you, Bruno. I wanted to give some insight because I noticed that discussion was going towards a point that we normally we have not resolved. Now there is this concept, and it's not related to this amendment. I noticed it was going towards of when you're supposed to pay VAT, and there's normally this concept that you're supposed to pay VAT when you're VAT registered. It even goes into the dates that you must have a VAT certificate, and it's on that date indicated in the certificate. And of course, these areas have not been litigated upon the most, but have an interesting comparison. You see, if you look at the Section 4 of the Income Tax Act, the way it is couched, it will tell you that subject to this act, you're supposed to pay income tax. But you see that charging section of 4 is subject to the act, so it follows that there are scenarios whereby you might not pay. Now, if you look at this section 4 of the Value Added Tax Act, it has no subject to. In fact, if I read it, it will tell you that a tax to be known as value-added tax shall be charged in accordance with this act on every taxable supply made by a taxable person, every import, other than that, the exempt, and the supply of imported services. So we had those cases where we're debating of URA comes across you and you're not VAT registered, but they look at your transactions, and when they do backwards, they find that you ought to have been registered. Now, they would give you an assessment of VAT. Now, normally the arguments were, but the certificate that I was given post-dates the assessment. And we had cases of post-bank saying, it is the date on the certificate. It is when you are registered. But then later on, we had another bite at the cherry. And this case involved a law firm. Someone had a law firm, they split. After splitting, they started operating as we normally do. But the registration with Law Council took some time, and even URA rejected their VAT application because Law Council had not yet approved. So by the time Law Council approved, that's when VAT gave them a certificate of registration as per the Law Council. So the assessment that our team gave this law firm was for the transactions before they were registered. And they argued that, according to Post Bank, and according to the way we understand the VAT Act, we can only be made to pay VAT on the date or when we are registered and at the date of the certificate. I think the tribunal agreed with them, but at the High Court we managed to focus on Section 4, and we said that when it comes to paying VAT, unlike income tax, which is subject, here it is as it is. So there is this concept of you have to be registered for you to pay. No, the mechanism, if you're transacting, we take it that amount is inclusive of VAT. But connecting to this amendment and the IFRIS question, I think the general picture should be that if you're registered VAT, then you should charge. If you're not registered VAT, then you shouldn't. But if there are circumstances whereby you transact as a professional, and for some reason you're not registered for VAT, my view would be that you're still liable to pay VAT if the supplies you make are taxable and you qualify as a taxable person, if they are imports and they are not probably exempt. So that is the analogy I wanted to bring in. Basically, to answer the question, it's not upon registration that you should pay VAT. The test is taxable supplies and taxable persons. Imports, the certificate is in no way a consideration for you to pay VAT. It is charged on the supplies, the person.
Thank you, Tony. Maybe my personal question, and before I get to the very last one from the gentleman over there. There is a penalty for failure to issue IFRIS, and the penalty is stated as double the tax due on the goods or services. So if I am a professional or if I am an SME, I do not meet the VAT registration threshold, but I'm within the sectors that are required to issue IFRIS, and I do not issue IFRIS. The penalty in the double the tax due on the goods, how will it be arrived at?
That's a very good question. I think if the supply you're making does not attract any tax, then definitely the provision is redundant. Yeah. However, that does not stop URA from taking other active steps to ensure that you're compliant with the law. And that is why we have litigation and other ways for us to ensure that you comply with the law. you might, the IFRIS test, the IFRIS penalty might not catch you at this point in time because there's no tax. We're not going to double zero. So the other ways that we will find to ensure that you are compliant.
Thank you, Brian. And we will take the last question from the gentleman over there, and then we'll call it a day.
Yes. Okay. Thank you all. This is for our interest all. Taxation should be for everybody. Pay taxes, whether you are a villager, whether you are a literate or illiterate. At the beginning of URA, 1991, I happen to have been an employee here. One of the undeclared objectives of URA was to simplify the taxation language from, we are talking English, but from the English to me. I come from Tokoria. So if I'm on Welsh, I should be able to read in my language what you mean by income tax, those changes and so on. Maybe this is why we are always undercorrecting. What is being done to make sure that me in Welsh is able to read the message of any tax policy, and I oblige. Thank you. You are a yeah. You remember Edward Ragusiao was the first Commissioner General, and he had come with that intention of simplifying the language of taxation.
Thank you, sir, for that very pertinent question. Indeed, it would be in everyone's interest, and indeed it is in URA's best interest to have the tax laws and the tax procedures well understood by the taxpayers. And as such, URA has taken and is taking deliberate steps to ensure that the tax laws, the tax policies, the tax measures reach out to the people through different programs. We have an entire tax education division in the Strategy and Risk Management Department, which caters to that. But in line with the specific question on translation, they do translate laws, amendments, whichever developments. They translate them into different laws. We have interpreters on hand. And I think in terms of tax education, you've seen different interventions. For instance, the Ask the Commissioner General, we have it in Bukedde. We have it, that would be in Uganda, we have it in English and other languages. So there's a deliberate effort by the URA to really simplify the law and ensure that taxpayers are on board, and which, like you rightly stated, will be very pivotal in ensuring compliance from the taxpayers.
I want to go to a bookshop. I am from Weshu, a bookshop in Barara, income tax, whatever you call it, I buy and go and read. 1991, we're almost and no effort has been done. Really, that is unfairness. And I think that's why we are undercorrecting. People would want to pay, but pay against what understanding. So, invest in the translation. This in the major language of Uganda, basic, so that I don't have to wait for Mr. What is the Commissioner General's name? Ask the Commissioner General. I don't have to wait for the Commissioner General to answer. Let me read and understand and I pray. Because ignorance of the law is not first, should not be counted against taxpayers, really. I think that's very, very important.
Thank you so much, sir, for that very.
For that, I am called Vincent Tature. I was one of the first, I'm actually senior revenue officer number 68.
Thank you so much, Mr. Vincent Bitature, for that very valid concern. I'm sure the Uganda Revenue Authority has taken it in good faith, and I'm quite sure they will take action upon it. Ladies and gentlemen, that marks the end of day one of the ULS Tax Law Symposium.
Excuse me, there are a lot of questions there.
Apologies, we had inadvertently left out our colleagues that are appearing virtually. Anonymous attendee, since local governments and other government agencies in Uganda collect both taxes and fees using payment reference numbers generated by URA, why is URA not involved in the objection and dispute resolution processing arising from assessments by these institutions? Given that these entities act as agents of URA in revenue collection, wouldn't it be more effective for URA to also play a role in handling disputes, whether at the appellate level or another appropriate stage, so as to streamline dispute resolution in tax matters? Mr. Brian, is that something you'd want to respond to?
I don't think the question is clear. We got lost somewhere because, in as far as it's a tax dispute, URA would be involved. So unless attendees inquiring into the fees, and I think again, if there's any need for involvement of URA, we are always on board to resolve any dispute. But clearly, if it's a tax matter, URA is involved and participate.
All right. I think one of the areas of contestation between taxpayers and the local authorities perhaps relates to property rates. Yes, and the dispute resolution process sort of doesn't involve URA. I want to think that the comment came from that perspective. Yes, please, there is a hand.
Thank you. I just want to just give some context on that. My name is Edward Semanda from Business Policy. So now, when you look at some of those local government levies which are collected, they're usually governed by their respective laws, which give the dispute resolution. For example, the property rates you have highlighted, it gives rise to a valuation court. Like after your property being valued, you are given some time to go to the valuation court. And therefore, after that process, I think that is enough, because he said that, he or she said that they act as agents of URA, yet I think in this particular case, we just act on their behalf since we are just a way through the system of payments.
Yes, thank you so much for that very valid response. Miss Gertrude Naseje, does Senior Okuja take into account the legal rights imposed on banks as mortgagees, including a right to sell? How does he reconcile that with being an agent in a foreclosure? Good thing Mr. Okuja is still here with us. Maybe in about 30 seconds, if you could respond to that comment that is directly addressed to your presentation earlier on.
Thank you so much. The question relates to legal rights.
Yes.
I did indicate that under the Mortgage Act, at least to the best of my knowledge, there is no provision in that law that makes the mortgagee in possession the owner of the property. And therefore, they cannot be the ones selling the property. They can only be doing that in the capacity of an agent. So unless there is another provision that I'm not aware of, that is the position that I hold.
Thank you so much. Obviously, the discussions will continue, but moving on to Belinda Lutaya's question directed to Tony in regards to URA assessing, going back to assess VAT. Is the input tax prior to registration for 6 months taken into account or accepted by URA? In other words, where you say that regardless of the non-registration, the taxpayer in question was required to register, and therefore you are assessing them retrospectively, that's before the registration, are you going to allow them to claim the input?
Well, the way the input mechanism works is that when you're claiming it back, issues of verification come in, but it shouldn't be an issue, in my view. And I think that was an issue that was slightly addressed in the case of Chestnut some time back that we did, because there's a provision on refund of input VAT. And the argument by then, Haruna has since left here. The argument was that some taxpayers set up, though the provision is designed, you find a taxpayer who registers, sets out to do business, let's say like in the case of Chestnut, and while in those circumstances their project is to have, let's say, Arena Mall, but which is their nature of business, but you find they are transacting not in their own main business, but there is VAT they claim before going to the actual project. So that was more of an argument of someone either trying to get what they don't deserve, but the ruling was that no, law provides so, and the input was claimed. But now to the issue of non-registration, in my view, it would be ideally okay. It would be okay. The challenge would be as to how you prove it. And that's where the law is unfair when it comes to issues of maybe taxing illegal income or income that is through activities that are offshore. The way the system is designed is that if they get you, let's say, carrying out activities that are illegal, they will tax you. Now, as to whether in the process of taxing you, they should recognize the costs you incurred, the jurisprudence differs. You will find cases under common law arguing that whereas I was a money launderer or engaged in, let's say, prostitution, which was also give me my expenses, but courts have said no, there should be no benefit to that. But if, let's say, you're engaged in an activity that is legal and you've been given an invoice, and VAT is there, in my view, would present that issue and we look at it. It should work both ways, but as to how you prove it, it would be an issue. Yeah, thank you. I hope Belinda have answered you for that. Thank you.
Thank you so much, Tony. Do we have any other question from our online audience? I want to believe that we have exhausted the questions. If you could scroll up just for completeness. All right, ladies and gentlemen, that marks the end of day one of the ULS Tax Law Symposium 2025. Thank you once again for making time off your busy schedules to come and have the discussions with us. We started off with an insightful panel discussion covering dispute resolution in relation to tax. The discussion centered on alternative dispute resolution and appeals to the Tax Appeals Tribunal, the High Court, Court of Appeal, and Supreme Court. We then had another discussion on recent trends in capital gains taxation in Uganda, and then we wrapped it up with a presentation from the team at ABAC and also Mr. Brian from URA on the recent tax amendments. The symposium will continue tomorrow. We will have a presentation on M&A, that's mergers and acquisition, the relevant tax issues to take into account. We will also have a panel discussion on key recent tax decisions, in case you want to know what decisions have come out of the Tax Appeals Tribunal and the High Court and what these decisions mean for you and your business. Don't make sure you do not miss the discussion. We'll also have a panel discussion on transfer pricing and international tax considerations. And then we'll also have a presentation on prosecution as a tool to combat tax evasion. In the recent past, we have seen URA going after tax professionals that it thinks are enablers of tax evasion and tax fraud. So again, that will be an interesting discussion to keep tabs on tomorrow. Otherwise, that's all we had for today. There is lunch. Don't go hungry. The ULS has organized lunch. So as you prepare to go about your other responsibilities throughout the remaining part of the day, ensure to grab a plate of food before you make your way out. Ladies and gentlemen, thank you so much for attending.